ಕೋರ್ಟ್ ಹಾಲ್ ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ. ಕೋರ್ಟ್ ಹಾಲ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
My lord, there is an urgency of matter. My salary has been deducted. This honorable court has already passed an order by reducing the maintenance amount from 20,000 to 10,000, but which was passed by the family court through salary attachment. Now the respondent one has deducted my salary as per the family court order, which is he has bypassed the.
Then why, in that case, you should tell him that this is the order of the court. Why again the court has to clarify that? There is an order.
My lordship, already
Then
we have
what's
done
the
our best,
clarification in
but they have given an endorsement saying that we'll deduct as per the family court, which is nothing but contempt of court, my lordship. So I'm requesting to list the matter tomorrow. Otherwise, even this month, my salary will be deducted.
Tomorrow.
Same order had been expired.
When?
1 week. We have filed an IA for extension of.
Tomorrow. Yes.
Your Lordship, there was a direction from this honorable court to the respondent to give a consent for the renewal of passport, Your Lordship. The respondent had denied it twice, Your Lordship. On the last date, it was again made clear, Your Lordship.
First.
Again.
First. Yes.
My lordship, I'm a respondent appearing party in person. And last hearing date, I could not attend because the trains were getting cancelled from Mangalore. And I have managed to come in today morning. I'll comply. The only objection by the office is that I'm not signed the counter, which I will go right away and sign the counter. If the matter can be listed tomorrow, I'm coming all the way from Bombay. So I cannot go back, and if in case return, if again the trains get cancelled, I'll be in a soup.
Why do you anticipate that every time
Because it has happened three times continuously.
So the fag end of the vacation, all the matters, just because you have come, it's not possible.
If it is possible for tomorrow, my lordship.
There are so many matters already tomorrow. How many matters are there tomorrow?
36 matters, sir.
Huh? Yes.
Much obliged, my lordship.
Complied. Page-wise adjournment. Page-wise adjournment. Page 1. Cell number 1 to 7. Page 2. 8. Page 3. 9 to 10. Page 4. 11 to 16. Page 5. 17 to 21. Page 6. 22 to 28. Page 7. 29 to 36. Page 8. 37 to 41. Page 9. 42 to 47.
One submission, serial number 32, my lord. I'm sorry. 32, in
Yes.
that there's a minor has attained majority in June. Maybe we have to file an application to remove the guardianship, and it's only granting 10,000 per month to the child, not to the wife. That is a challenge now. Up to the date of majority, that is June, he has attained majority. That is the position. That is the case, my lord. And now interim order is passed by this honorable court, 5,000, and that is being paid. 10,000 is what the trial
No,
court.
no, what do
granted.
you want?
Please grant me some time, because my learned friend, the other friend, I could not contact our telephone. That's why he has to file an application to remove the guardianship, maybe because he
No,
has
because you have
attained.
to, if you're making a mention, you should be aware of it. You should inform him.
Very well, my
So
lord.
let's see when the matter reaches.
Very well,
Yes,
my lord. I will mention at that time. Okay.
Yes.
Very well, man.
Page number 9, cell number 42 to 47, page 10, 48 to 50.
My lords, serial number 49, we appear for the respondents. We have not received any instructions based on that, my lord. So no instructions has been given to us. So kindly give us 1 week of time, my lords.
Have you informed the other side?
Yes, my lords.
At the request of learned counsel for the appellant for this matter on 29th of October. Yes.
Much obliged.
Cell list number 2, cell number 1 to 3. Page 1, for preliminary hearing, cell number 1, Rupesh Kumar S. For petitioner.
Petitioner,
Rohit
ma'am.
MC.
Yes.
Copy, I have not served the copy on this.
Any interim order in your favor?
No, my lord. Notice is not ordered yet, my lord. Yes, filed wakalat.
I have already filed my wakalat.
How can you file wakalat?
Because there was a mentioning in before the trial court that they have filed an appeal. So
No,
just on
I
the.
can understand you have filed a
my lord.
caveat.
I completely understand on that.
So let's see. Is it a case for
Sir, in the
admission or
copy.
not?
Yes, yes.
Yes. Oh,
Case, the respondent has filed application under section 24, man. The same came to be allowed, my lord, thereby granting 5,000 as monthly maintenance, man.
to the wife.
Yes, ma'am.
Hmm.
Lord, in this case, the trial court, my lord, at page number 15, my lord, of the impugned order, man,
Hmm.
at paragraph number 10. The respondent has pleaded that the petitioner has got income of rupees 50,000 per month, but the petitioner has stated that his income is very meager and he is getting daily wages of rupees 897 per day and an average of 26 working.
What is your income?
20,000. And that finding is there, my lord. Here, I also produced my salary.
What
slip.
the court has given is 5,000.
My lord, yes, my lord. But the further, my lord, I may be permitted to read that paragraph, my lord. The payslip submitted along with the
You're reading at which page?
page 15, my lord,
Oh.
paragraph number 10.
Yes. Yes.
The payslip submitted along with his declaration shows that he has been drawing monthly salary, and in the month of July 2023, he has drawn rupees 20,523. The amount of interim maintenance claimed by the respondent is very meager, and it is only rupees 5,000 per month. Since the respondent has no source of income, she requires at least rupees 5,000 per month for livelihood. Hence, it is necessary to direct the petitioner to pay maintenance of rupees 5,000 per month. My lord, in this case, the assets and liabilities filed by the respondent, my lord, is at page 52, my lord.
Yes.
54, my lord, is the relevant portion, my lord, wherein she has admitted that she is getting monthly salary of rupees 12,500. So
Where do you
although
get
there is
that?
a statement, my lord,
Where do you get that?
page number 54, my lord, FLE at F, my lord.
At F,
At F, my lord, bottom.
designation operation assistant.
Yes, ma'am. So although she has admitted in her statement of assets and liabilities, ma'am, that she's earning 12,500, ma'am. The same has not been considered, my lord, by the trial court.
I'll file my objection, my lords.
Then we'll stay this.
Yes, she is working
And
as.
why the order, then order itself has to be set aside because it's contrary to the pleadings of the parties.
Yes, my lords, but she was actually working, but the present scenario, I'll just verify.
Here you have to mention, not was.
Yes,
What are-
I understood.
What is as on the date of this?
Yes, ma'am.
You say that you are working. And why did the
I'll-
court give such a finding? Learned counsel for the petitioner submits that the family court has granted maintenance of an amount of rupees 5,000 to the wife. And the court has given a finding that she has no source of income. Learned counsel has drawn the attention of the court to the statement of assets and liabilities where She has stated that she is earning an amount of rupees 12,139 per month. Considering the same, there shall be stay of all further proceedings in so and so, version to the order dated so and so, till the next date of hearing. What is your name?
Roshan MC.
So and so submits that
Yes.
as instructions to file wakalat, post post on 28th of October. Yes,
Sale number 2,
Great.
Purnima. Petitioner.
Senior.
no, he has
counsel.
already filed wakalat.
My lord,
MC submits that, he'll come up with objections.
Senior counsel act with the matter to unproven.
please, my lord, am I audible to your lordships kindly?
Yes,
Please, my lord, it's a husband's petition challenging the impugned order awarding 4,500 rupees per month as interim maintenance for a man who is living on 1,200 rupees old age pension from the state government. May I take your lordships to the annexer F, page 40, my lord, it starts. This is a suit filed by the respondent wife claiming that she is in possession of the landed properties. Take your lordships to page 44 for a minute, my lord. Yes.
are you appearing in WP 23, item number 2?
Yes, my lord.
Impugned order is
45.
at page number 14.
44.
14 is the impugned order.
Yes, my lord.
Please come to the impugned order first.
Please. Starts from para
Where
3.
the reasoning, where the reasoning starts.
Reasoning starts from para number 8.
Yes, please read that.
Yes. The petitioner has filed the petition as 125 CRPC against respondent seeking maintenance of rupees 30,000 per month to the petitioner. Along with this petition, petitioner has filed IN number 2 seeking interim maintenance of rupees 20,000 per month from the respondent during the pendency of the proceedings. Petitioner has invoked the provision of section 125(2) of CRPC, which is not a correct provision of law, to seek interim maintenance. The application should have been filed under section 125(1) CRPC. The content of the petition with respect to negligence on the part of the respondent to maintain her and content of the respondent that the petitioner herself has caused ill treatment to him and she refused to live with him or neglected to maintain the petitioner, and counter allegations made against has to be appreciated only after the evidence of both the parties on the matter. As already discussed, at this juncture, it is safe to rely on the admitted facts and not proper to go too deep into the allegations and counter allegations. The admitted fact in this case are that the marital relationship between the petitioner and respondent is strained and they are living separately. It is the case of petitioner, the respondent owns agricultural land and rupees 50,000 per month. The respondent himself has pleaded that he owns it, but he has got only a small share, which is to be identified in the final
Please come.
proceeding.
The petitioner before this court is the husband. who
He's
is
a man,
who is
1,200
71
old age
years.
pension.
The wife is 66 years. She filed a petition seeking maintenance under section 125 at rupees 20,000. And she sought an interim maintenance of 20,000 per month. It is a case of the husband that is only receiving 2,000 as pension, and apart from that, he has no other income. And it is the case of the husband that the wife is having 2,50,000 income. from
All the
income
properties are in
from-
her hands. She is in possession, cultivation, and enjoyment.
The court gives a finding that the husband might also be having more income and granted the maintenance of an amount of rupees 4,500. Considering the fact that there is no other evidence that the husband is earning more than 2,000 before the court, there shall be stay of all further proceedings. So and so, the file of so and so.
Obligation. Grateful, my lord.
The petitioner is permitted to take court notice on the counsel appearing for the trial court for the respondent file a memo to that effect.
Please, my
Memo shall
lord.
be filed by 28th of October. This is matter on 30th.
Obliged.
Next,
Sale number 3, Visitation for petitioner.
Connected matter is posted tomorrow.
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 Post along with, give the number. Post along with so and so tomorrow. Yes, next.
Number 4. Sebastian.
Appearing for the petitioner, Your Honor. The impugned order is at page 11.
On the mic.
The petitioner and the respondent,
Yes.
the petitioner and the respondent, they got married in the year 2016.
What is impugned order?
The impugned order states that at para 17, page 24.
Petition is directed to pay monthly maintenance of 10,000 to
Monthly
the.
maintenance of 10,000. The application was filed for a sum of rupees 30,000. It is an admitted fact that I'm a HL employee and I earn about 1 lakh. The case of the respondent is that she has been receiving money into her account. The application was filed in the month of June 2023. The petition was filed in the year June 2019. They have been separated since 2017. 2022 June, she files her objections. Subsequently, it was posted for the examination of the witness. The witness was examined in part, and during the cross-examination, an answer is elicited that he works in HL and he's drawing a salary of 70,000. Subsequently, this application came to be filed. In the impugned order, the court clearly states that there is so much of transactions in her account. So much of money has been credited into her account and she's given no explanation for that at all. And in her application, which she files in the year 2023, June, she states that currently she is unemployed. But she does not state any reason for her
Anyhow,
unemployment.
It's only 10,000 that's granted. You're earning 1 lakh.
Your
This
Honor.
has to be finally heard.
Your Honor,
No. Yeah, we can understand an interim order when you're not in a position that
the
if
amount.
she's not entitled, she's not entitled
the
once
amount
a
can-
matter is heard finally.
Documents have been submitted to support that why she needs this maintenance, not a single document.
We'll see. Notice to the respondents. Petition is permitted to take out notice on the counsel appearing for the respondent to the trial court. Shall file a memo to that effect by 21st of October. Poses matter on 23rd October. Yes, next.
5, Revanna Bellari, for petitioner.
In this case, my lord, I have challenged the orders of trial court impugned order, rejecting the application to get the witness, to examine the witness in the court hall, as because several allegations is made by the husband, and the fake report has been brought by the husband in colluding with the forensic science laboratory.
Let's see the impugned order. Please come to the order.
Please.
You're for the husband. He's for the wife. Yes. What is the application? What is the IA?
Application is, my lord, the application is one for to treat the 112
Has
of
it
the
come before the court earlier also?
card.
Please, my lord. My lordships recollect, I had argued before your lordships regarding adducing of evidence through the video conferencing mode, where the DNA test was acknowledged by the director. My lordship said there is no positive order as such pass. Therefore, we'll direct the completion of the trial within 6 months, and, which is the case. Please.
My lord, what happened in this case, my lord? The application is filed for consultation of 112 of Evidence Act, my lord. As could be, the husband has been unequivocally admitted that he is along with the wife, even give birth to the child. Till then, give birth to the child. Thereafter, only the relationship.
No, before that. Respondent is who? Respondent is the husband or wife?
Respondent is wife, my lord.
Respondent and a section, not in this, the trial court is different.
Yes, ma'am.
Respondent is the wife.
ma'am. Respondent is wife.
Application is filed by respondent seeking an order to direct the petitioner to secure the witness, forensic scientist who submitted DNA report physically before the court to examine him.
Yes,
What
ma'am.
did the court do?
Court has rejected the application.
What is the reason given by the court?
The reasons given in that there are works to the witness. Therefore, he could not able
Please
to be.
come to para number 11.
Please, page number 11.
Para number 11, page number 9. Read from there.
Please.
Yes.
I have gone through the records and pleadings of both the parties. Petitioner has filed this petition seeking the decree of divorce on the ground of cruelty under section 13(1)(a) of Hindu Marriage Act. In the petition, petitioner has contended that the respondent has avoided the physical relationship with him. Respondent used to speak with another person on mobile phone daily for a couple of hours without fail. And when the petitioner inquired, it is the facts of the case, my lord. And the respondent used to hide the mobile phone.
No, We'll understand.
And never shared her mobile phone number with the petitioner and family members. It further stated that there was no cohabitation and excess between the couple till 2012-2015. On 6/1/2016, the respondent stated that she is suffering from the stomach pain. And when she was taken to hospital, the doctor was confirmed that respondent was pregnant for 2 months, 3 weeks. Since there was no cohabitation or excess with the respondent for last 6 months, he inquired the respondent about pregnancy. For that, respondent threatened to commit suicide if inquired about the pregnancy. And the petitioner has strong doubt on the respondent leading adultery life. All these allegations are denied by the respondent in the objection statement. But when the petitioner has filed application for DNA test of the child, petitioner and respondent has given no objections. And accordingly, DNA test was conducted at CFS Central Hyderabad. Report is received from the CFS Central Hyderabad through register post. Now, the order considered for the report of CFS Central Hyderabad. Petitioner intended to examine the forensic scientist who issued the DNA test report. The witness summons was issued to the.
Yes, I've seen. What's wrong with the order?
Pardon?
What is wrong with the order?
My lord, what happened in this case, my lord? The fake report as brought by the husband, the petitioner, along with the petition itself, my lord, without taking the blood. Therefore, the respondent has immense faith over the husband that the child was born out of the marital relationship with the husband petitioner only. That's why so much of confidence only, on that so much of confidence only, she has given no objections to get the test. So that test report has been malifiedly bring by the husband petitioner in colluding with the officials. Therefore, the petitioner,
So what is a party who is in Bangalore?
Yes.
What the forensic department of Hyderabad? What is how can he manipulate?
My lord, my lord, the mother has no rights to draw the blood from the child, my lord. So that it is against the Article 21 of the Constitution, my lord.
Then you examine him.
My lord, what happened in this case on 19/9/2024, mechanically looked into these judgments, my lord. What I brought before this honorable court. What I brought before this honorable court in Jianka case also rendered by a division bench of Justice, Madam Nagaratna, Madam. There also they have been held that the child blood cannot be taken.
This is not,
back
we are not on the point. We are on a point. An application that is filed by you seeking to examine so-and-so was dismissed. Now we are not going on to the point whether the said report or whether the sample can be collected or not.
By all right, my lord. But on the day of 19/9/2024, when the date is fixed for the taking the evidence of the expert through VC on 19/9/2024, this petitioner has filed the application for adjourn the case because the advocate is not available. Because he is coming from the Rani Bennur, nearly about 46 kilometers to the Davangere. That is one thing, my lord. One thing, my lord. Where the court has been recorded the evidence of the expert, my lord, by delinking on so many times and low voice and murmuring sound, and as such, my lord, on the imagination, the trial court has been being recorded the evidence of the
Please read what is the order. There is no order against you in this.
Yes, no, not that, my lord. Because as such, I am incumbent to cross-examination because their advocate is age of 70 years. He could not able to be cross-examination for lengthy over for 2 hours or 3 hours, my lord. That's why, my lord,
video conferencing rules and that is specifically for all these experts.
My lord,
They will not waste their time coming to the court every time.
Your Honor, kindly see in the gazette, in the documents, I produced I produced the document at serial number 2, wherein in the 6.2, my lord, any proposal to move a request for a video conference should first be discussed with the other party or parties to the proceedings. There, they have not taken any consent in this case, my lord. And more so, my lord, further in this case, there is no any, moreover, it is a civil case, my lord. It is a civil case. They are sleep over for length over 5 to 6 years. Now they want to be examined at earliest in order to get the report to be admitted. And they take in favor of the petitioner.
Then the court has to think that you are trying to come over, you are filing these petitions only to drag on the proceedings, nothing else.
No, not my lord, not my lord.
Yes, it is.
Even, no, that is not so, my lord. That is not so. We are ready for.
What do you want? What do you want?
Why I want the witness to come before.
You can't compel the witness to come to Bangalore.
Yes, because they orders in the first judgment in the Deepak versus Ramesh case.
Yes.
Where, my lord, in the pair number 13 of the judgment, my lord, the right to lead evidence in pivotal to fair trial
Mm.
and partakes of the character of the natural justice and fair play.
Mm.
No doubt where a party is unconsciously indolent, the court may put its foot down and close the right of the party to lead evidence in physical. There the case in the judgment of the case of the judgment of the
Yes,
Supreme
yes.
Court, my lord.
Yes.
Where our lordships have been pleased to be held in the judgment of Deepak versus Ramesh Shetty case I have produced in the date of 8 April 2022. There also on consideration of the gazette notification, also the consent is to be taken from the party respondent who agreed to. Moreover, Your Honor, kindly see the person who is coming for to give evidence. He is not in remote area, my lord. He is in Hyderabad, my lord. He would have very hamper opportunity to come over to the Davangere by flight over, and there the expenses is ready to bear by the parties. There the case a remote user means a user participating in the court proceedings through video conferencing at a remote point. If at all he is in a remote point, it is very easy to be access to him to give evidence, to enable to be speed the matters. So that Your Honor can see for step for 5 to 6 years now he have come up with this application. Now there I will suffer, Your Honor, because if at all this honorable court is not pleased to be allow this petition to get the witness in the court hall to cross-examination, because on several things, on moreover 112 of Evidence Act is there, and moreover in the evidence itself, Your Honor, in CRB 61/18, he unequivocally admits that he has made all Shanti Puja, etc. As because sun is born in a Mula Nakshatra, why he has done the all puja and etc. My lord.
You should ask him.
That's why, my lord. All
He has
things,
done all that.
all
You should
things
ask
should
him.
be go into looked into
Yes,
to
yes.
save the allegation
Yes.
to prevent the allegations, my lord, made against the wife
Yes.
by bringing a fake report along with the petition.
Yes.
He has filed the petition along with the petition, a
Yes,
fake
yes,
report also.
yes.
That's why, my lord, the respondent wife has completely doubt over this husband petitioner in order to get this report against the wife respondent, my lord. That's why, my lord, it is the very important role is to be taken place in this case, my lord, because I request this honorable court for given opportunity to get the witness before the court and get the cross-examination. Otherwise, she will be put into the every hardship, and moreover, child will be suffering at the hands of both the father and mother quarrels,
Yes.
and he will lose his respect in the society, man. That's why, in order to save this all these lapses, I request this honorable court. It is a fit case to order for allow to get the witness before the court to cross-examination from the respondent side, wife side.
Agreed with the orders passed in. MC number 306 of 2019, where an application is filed under section 151 CPC dated 9th September 2024. The wife is before this court. The respondent Karen, who is the husband, had filed the MC 306 of 2019 seeking annulment of marriage.
Yes, sir.
Seeking
These are
annulment of
dissolution
the
of marriage.
marriage. It is a case of the husband that he himself and his wife were staying together at Hubli. They went to hospital as she was having stomach pain. And during the checkup, it was found that the wife is 3 months pregnant. And he was happy after hearing that his wife was pregnant. And the son was born on 26/2016. No. It is a case of delete all that. It's a case of the husband that. Where is that, your, it is a case of the husband that. In the case of the husband, that the wife is living in adultery and she had extramarital relationship with other person. And there was no cohabitation and the child is not born to him. He is disputing the legitimacy of the child. And earlier he has filed an application for DNA test, for which the wife has given no objection for the DNA test. And accordingly, the report is also placed before the court. At that point of time, this application came to be filed by the wife. Seeking an order to direct the husband to secure the witness, forensic scientist who submitted the DNA report physically before the court to examine him. That application is disposed of by way of this order, where the court had dismissed the application to secure the witness physically. However, the office is directed to contact the witness through email about the date and time of his availability through video conference examination. While passing such an order, the court had observed that as no objection was given by the wife, the DNA test was conducted and the report is received from the CFSL Center, Hyderabad, to registered post. In order to consider the report of the CFSL Center, petitioner the husband intend to examine the forensic scientist who issued the DNA test report. The witness summons were issued to the forensic scientist to appear before the court to give evidence, but he submitted his inability to appear physically and has stated that he'll give evidence through video conference. The court observed that the High Court of Karnataka has framed the rules for recording evidence through video conference. There is provision for recording evidence through video conference. Through video conference, witness can be seen and questions can be posed as put in regular court. Respondent wife can put the questions to the witness in respect of objections raised by her to the DNA test. Therefore, by examining the witness through video conference, no prejudice would be caused to the wife. The forensic scientist will be having a lot of work and they'll be busy in preparing reports. If the witness is secured physically, it will cause much inconvenience to the witness and also the department. When rules are framed for examination of witnesses through video conference, no harm would be caused to the wife. And the court felt that the wife has not made out any sufficient ground to secure the witness physically. And accordingly, dismissed the application and directed the office to contact the witness through email about the date and time of his availability. Aggrieved thereby, the wife is before this court. Learned counsel for the petitioner has submitted that the DNA test cannot be conducted and it is contrary to the law laid down by a division bench of this court. He submits that unless and until the forensic expert is physically examined, it will be difficult for the wife to elicit the evidence. Further, it is also stated that the officials, the forensic department have colluded with the husband, and such a fake report is placed before the court. Unless and until it is physically examined, it would cause lot of hardship to the wife. He had relied on judgment. He has relied on an order passed by High Court of Delhi in case of Deepak versus Ramesh Sethi, dated 8th April 2022. Submits that In the said judgment, the court has held that the right to lead evidence is pivotal to a fair trial and partakes the character of natural justice and fair play. No doubt, where a party is unconsciously indolent, the court may put its foot down and close the right of the party to lead evidence. Else, as adversarial litigations are meant to be tried after allowing the parties to an adequate opportunity to place their respective stance on record. The court should not be hyper technical in the matter of granting opportunity to read evidence and the like. And the court, basing on this, Land Council submits that an opportunity should be given to the wife. A fair opportunity should be given to the wife. Then he had relied on the rules, video conferencing rules framed with the High Court of Karnataka, wherein 6.2 deals with any proposal to move a request for a video conferencing should first be discussed with the other party or parties add to the proceedings, except where it is not possible or inappropriate. Basing on this, Land Council submits that before moving such an application, taking such a decision, no consent was obtained by the respondent, and it is submitted that, viewed from any angle, the order of the court suffers from the irregularity and also causes a lot of hardship, and the same needs to be set aside. Having heard the Land Council for the petitioner, there is the material on record. The submission of the Land Council that the DNA test cannot be done on the child. That aspect is not, cannot be decided by this court in this petition, as the wife had given consent for the same. The test was done. Then coming to the aspect that that unless and until he comes physically, the scientist comes physically to the court, lot of hardship will be caused to him, also has no legs to stand. In that regard, it is submitted that the poor quality of video conferencing and other things, which can always be rectified and which can always be brought to the notice of the court. The submission of the counsel with regard to prior intimation to him is concerned. The intimation about his consent for the video conferencing. The witness is an expert. He has nothing to do with the case of the parties. Because of the differences between the parties, if these kind of allegations are made against the experts, nobody will come forward to give evidence. The expert is from Hyderabad. When the court asked him to come personally, he has requested the court that due to his work commitments, it is not possible for him to come. He can reduce the evidence through video conferencing. In those circumstances, the court has felt that it can be done through video conferencing. All the submissions that are made before the court appears to be that on one pretext or the other, the petitioner wife wants to drag on the proceedings. Like if at any point of time, if the video or audio is not clear, the court will be conscious of that and court will take care of it. Though this court in other cases, as far as the examination or cross-examination of the witnesses, the prime witnesses through video conference, who are staying abroad, has discouraged the said practice unless and until the rules are framed in that regard. But as far as the expert witnesses are concerned, video conferencing is the best method by which the work of the expert is not affected, and at the same time, they can adduce evidence before the court. In that view of the matter, this court finds no reasons to interfere. Accordingly, the petition is dismissed. So initially, this court wanted to dismiss this petition with cause, however, dismissed without cause. But he has not filed, so coming up for admission. That's it. Without notice, how can we? Yes.
This, my lord,
Authorization.
vegetation rights has been granted on 18/7/2024.
18/7/2024.
24.
You're for the father or the mother?
I am mother, my lord.
You're for the mother.
Mother.
What is the order? Let's go to that operative portion.
The operative portion, my lord. Before operative portion, the marriage ink page number 38, my
Just see it, then you can submit.
lord.
Let me just look at it, then you can submit the facts.
Yeah,
Let's look at the operative portion. What did the court do?
yeah, please.
Defendant is hereby directed to keep present the child between 11
Vegetation
AM
rights have
to-
been conferred, given, my lord, on first and third Saturdays between 1 to 11 to 2 p.m., my lord. To the respondent herein, husband, my lord. The crux of the
What
point,
is the age of the boy?
it is a minor daughter, my lord, about 4 years,
4 years girl.
4-year girl, my lord.
When is the marriage?
Marriage to 11/11/2018,
When the daughter born?
2020, my lord. That is
And from how long they are separated?
from 27/6/2021.
Hmm.
When the baby was 10 months old, my lord.
Huh?
When the baby was 10 months old, my lord.
Hmm.
From that day to this date, the respondent herein has not made any attempt not to know the name of the child.
But
Now,
this appears to be a suit of 2021.
my lord,
This appears to be a suit of 2021.
yes, by the respondent, my lord.
That's what I'm saying.
Yeah,
You are saying that he has not taken any steps, but he has filed this application.
yeah, but in spite of that, in spite of application is filed, he has not conducted gone with the matter from time to time. In spite of the matter was listed for evidence, cross-examination, or one or other way.
So what is the urgency for what this memo
Yeah.
is moved?
The reason I may straight away taken to my lordship with annexure R, page 124. Which was filed prior to 1.5 years for filing of the suit, my lord. Vegetation rights, my lord, for filing an application.
124 is FIR.
Yes, the FIR is the contentions are in the at ink page number 126. It is in Kannada
Filed by whom?
by the mother
Stating
against the father, my lord,
Stating that?
stating that they have made an attempt to disturb the child, kidnap the child, and to make harm to the child. And they have mentioned, categorically mentioned, that the child, even if the disturbance is caused to the child, it is going to affect the interest of the mother. Thus, there is a great threat to the security and safety of the child by the petitioner, by the respondent here, my lord. As a result, without looking into this consideration, the learned trial court, family court was pleased to allow the visiting rights, my
I
lord.
remember some grave urgency, some health issues were projected before the court.
Because the urgency is, my lord, if he is permitted to visit the child, there is every likelihood of poisoning the minds of the child, my lord.
That we can't help it. That we can't help it.
The child will not identify the father, my lord.
Let him identify. He should identify who is his father, and he should know. Those are not the grounds.
No, because he has made all efforts all this litigation started because of properties and monies, my lord.
Now we are
it is
only concerned with
only-
what is wrong with the order. And the reason what you say is that she gave a complaint, that cannot be a reason. The father has every right to see the child. If something is not right, something is not going right, please tell the trial court that it is not happening. First of all, they have to meet. First, let him meet. Once he meets, if something is not going, you can tell the court that please modify the order. It's not going well with the child. But you cannot come to the High Court on this reason.
No, because it is not only one FIR, my lord. There are seven,
When there are
seven, eight
when
FIRs.
there are there are disputes between the wife and husband, they will file 100 affairs. Those are not the reasons for the court not to grant visitation to the child. That too, where did the court grant? In the mediation center. That too for a very short time. Even that also, if the mother do not want to complain and come up with all this.
The whole difficulty is the mother, the only care taken by the mother. Custody, it is in the custody of the mother, and she is taken the care of the child. And if it is disturbed
How it is disturbing? How they are disturbing that? How it is disturbed? Why what she wants forever, she will not let the husband see the child. Is it fair on her part?
No, let my endeavor is let it if the ad interim order of stay is granted and in
No.
person. No, my endeavor. Kindly appreciate this. I'm for a moment. What is running in my mind? That is I'm expressing before your lordship. Even if the opportunity of notice and stay is granted, then at least a sort of iota of efforts will be going to be effected by the respondent father, my lord. Under these circumstances, my endeavor is just for a limited period.
No. No reasons to stay this order. Please come. Agreed with orders passed in I number 6 and OS number 345 of 2021 dated 18/7/2024. The mother is before this court. The I number 6 is filed by the husband, by the father, seeking visitation rights of his minor daughter. In that, the court had passed an order directing the defendant to keep present the child between 11 a.m. to 2 p.m. on every first and third Saturday, twice in a month in the visitation room, Nyaya, the law building, 4th floor, allowing the father and his mother spending valuable time with their daughter and granddaughter, and directed the father to pay the expenses incurred to the wife to keep present the daughter in the visitation room. Learned counsel appearing, aggrieved thereby the mother is before this court. Learned counsel appearing for the mother submits that in fact, when the girl is 10 years old, and you have the differences, the parties were residing separately. It is also submitted that the father had never taken care of the child till now. The child can't even recognize the father. And the mother is the sole caretaker of the child. If now the father is permitted to meet the child, he may poison the mind of the child. And it is submitted that earlier, the wife had given a police complaint stating that the father is trying to kidnap the child, and there are several other complaints of that nature. It is submitted that it's not in the interest of the child to meet the father. It's not in the interest of the child as well as the mother to meet the father. Next spell. Having heard the counsel for the petitioner, this court had produced the order passed by the court. The court had granted the visitation only on the first and third Saturday in the visitation room. The apprehensions that are placed before the court by the learned counsel for the petitioner are not the reasons to be considered. or this court finds no reason to interfere with the order passed by the trial court. While if pursuant to the order passed by the court, if while exercising the visitation, if any untoward incident takes place, or the boy is comfortable, the girl is not comfortable, or something else has happened, then the cause of action would arise for them to submit to the court what has transpired. Basing on that, the court will pass further orders. But without, but on the submissions of the council and with the apprehension, where the apprehensions the wife has are not the reasons for this court to interfere with the order in that view of the matter. This court finds no reasons to interfere, accordingly dismissed. Yes.
Litigant MP,
My lord, appearing for the petitioner, my lord, kindly pass out the matter. My lord, after battered matter, because my senior was
Yes,
arguing
yes.
some.
Seal number 8,
The bliss.
But appear for the appellants in all these cases. But one of the appellants, Srimati Arundhati Prabhakar, who is appellant in 2 matters and appellant number 3 in 3 matters, he expired, my lord, 3 days ago. I have sent the memos to be filed in the registry.
You submitted that second appellant or the first appellant?
Second appellant, my lord, in MF 2051 and 2069.
One of the appellant has passed away 3 days back, and the counsel for the appellant seeks time. Post these matters after vacation. That's on 29th of October for taking further steps.
Please.
Yes.
seal number 9,
Appearing for the respondent.
Petitioner.
Hemant
Kindly
Bhatt,
pass over. I request for a pass.
Kapil
Request for a
Dixit.
pass over. 2:30.
Yes.
seal number 10, Tagraj B, for petitioner, S. Sarvana,
No representation. Interim order is there. Look at the file.
There's one development, Manoj. Diverse case is filed and it is posted for judgment on 30th of this month. We'll take chance, Manoj, after that judgment is passed. Where in the meantime, you are also not trying to settle the issue.
Submitted the main petition itself as, the main MC itself is posted for judgment. And council submits that the settlement talks are going on. Poses matter on 22nd of October.
Please.
11,
Respondents, my lord.
Yes.
Indra,
But as per our memo of calculation, there is a due of rupees 1,10,000. As per their
Have you
calculation.
given her a copy of it?
Yes, my lord.
You have instructions on that?
Yes, my lord.
We complied the orders and on the last date of hearing, neither the advocate nor the parties was present. And he was ready to pay the arrears on 12/9.
So 1,10,000 is liable to be paid as per the order.
My lord.
Yes,
Where is it then?
1,10,000.
Hmm.
We are paying, every month we are paying 20,000 arrears and 5,000 rupees as per the orders of the sub.
When will, as per the order, it is every month 20,000
Every month 20,000.
towards
in
arrears. Towards arrears.
Yes, ma'am. And 5,000 to the respondent number 2.
That is continuing to pay and also paying 20,000.
Yes, my lord. My lord, but on the last occasion, they are mentioned in the court saying that there are no arrears. And after last hearing in this.
This
My
court
lord.
on the last occasion has directed them to file a memo of calculation as per that. Another 1,10,000 is due. As per the order of the court, he has to pay 20,000 every month towards the arrears and shall continue to pay 5,000 towards maintenance.
My lord, with
In
regard
your-
to the maintenance to the respond number 1, my lord, that is being quashed, my lord, by this honorable court by same order. My lord, coming to the respond number 1, my lord, though he is 30 years of old, my lord, he's autistic, my lord. And also he has mental age of 7 years old kid, my lord. I've produced those Niman's report in front of you, my lord. And
No, he is working as a attender in the college, National College, Jayanagar, Bangalore, wherein his mother is also working as a typist.
What is the material to show that he's working?
No, my lord, those documents were not submitted before the trial court.
No,
At-
how can he work as an attendant when she says that he's suffering with autism and his mental age is 5 years?
We are suspecting the document, my lord, because since 6 years he is working there. Now he is aged about 30 years.
Basing on what you are saying that he's working,
He is working as a attender, my lord.
how and how you know about it?
Yes, there is a document, my lord.
Where is the document?
This document my lord, I submitted. Annexure G, page number 48, my lord.
48.
Yes, my lord. This is secured after filing application under section 91 CRPC.
my lord, I do agree with that, my lord. But then he was fired 5 months ago, my lord. And his payments are not released, my lord, since he has done a lot of.
You can't make both the
We have
statements.
agreed to that, my lord. We have agreed
No,
to trial court
if a
also.
boy, you say that he is of, his mental age is 5
But
years.
he just gets
how will he work?
coffee and tea, my lord.
Huh?
Since the mother is working as a government employee, he just gets coffee tea, my lord. From the opposite shop, he just gets coffee tea, my lord. And that also he has made a lot of mistakes, my lord, and they have fired him, my lord. And he is not really, I mean, they're not released his payments also. We have caused legal.
How much
notice-
is granted to the boy?
My lord,
How much is granted to him as maintenance by the trial court?
I mean, my lord, in this matter, my lord, the petitioner and the respondent's mother were, my lord, they're not living together, my lord. The petitioner abandoned the children when they were 3 and 4 years old, my lord.
No,
And
no,
thereafter, my
you're
lord,
only, you have to submit about that boy.
yes, my lord,
How much is granted by the trial court?
5,000 rupees, my lord.
No.
My lord, together, my lord, the petitioner has to pay 12,500 to the respondents, my lord. Together, that 2,500 is for the litigation expenses, my lord. 5,000 to the respondent number 1 and 5,000 rupees respondent number 2 and plus 2,500 to the as a litigation expenses, my lord.
One-time litigation expense.
My lord,
One-time litigation expenses or every month.
No, one
not every
time.
month, my lord, one time, my
One
lord.
time.
So it is 10,000.
Yes, my lord. Together, it's 10,000, my lord. And they have not been complying with that, my lord. Plus, my lord, he is not only suffering from intellectual disability, my lord, and also he's suffering from respiratory disease also, my lord. Coming to respond number 2, my lord, she has diabetes, thyroid, and she has a open heart surgery when she was 11 years old, my lord, and she's still taking treatment for it. And she has PCOD, my lord. And also,
So for her, it's already 5,000 is granted.
yes, my lord, they're not coming for the trial court hearing at all, my lord. They keep
All that the court has to decide here. Or shall the court secure their presence in the trial court?
No, my lord, my lord.
Now, trial court's order is 5,000, 5,000.
Yes, my lord.
Your grievances, as far as the boy is concerned, this court has stayed.
Yes, my
So
lord.
this court can only look into that. Another 5,000, this court has not interfered.
Yes, my lord.
Yes.
Well, now the petitioner is retired. On 31/8/2024, he is retired.
What is
from
this, how much, what are his retirement benefits? The
commitments,
pension, how much he gets?
Pension is getting 3,900 per month.
My lord, per month salary was 60,000 rupees, my lord. He was a traffic controller in depot, my lord, Subhash Nagar depot.
He's retired now.
Let's see, that his pension is 3,000.
Yes, my lord, I will submit the document. I will submit the document.
We'll adjourn this matter to 29th of October. You pay
Yes,
to the son also.
I will submit the document.
You pay to the son also for till that time.
I'm paying, madam. Regularly I'm paying.
You're not paying, you're paying to the wife. Not to the son.
Son, my lord, he is working.
That's what is stayed by this court.
Yes, madam. For daughter, I'm paying. Son, this honorable court is already stayed.
No, they say that he's not working.
No, he's working.
Not working right now, my lord.
He's working. I submitted the document.
He was working, my lord, but then now he's fired, my lord.
It is
Since
a
he had-
collusive petition, my
Close
lord.
this matter
My lord,
on
let him continue to pay
21st
to
of
the son.
October. By the time the petitioner shall place before this court the details of the pension of the petitioner and also he shall file his objections with regard to the medical reports that were filed by the respondent and shall continue to comply with the interim order.
My lord, he can continue pay for the son also, my lord.
Huh?
He shall be.
We'll see, we'll see. Yes, he is raising his own objections for that. Yes.
Till number 12.
In this case, I am for the respondent, my lords. Last occasion, your lordship directed me to furnish the deposition of the wife. She is admitted regarding her previous employment status.
Copies.
In the domestic violence petition, my lords. Furnishing those details also, my lords.
First, let's see, what are the facts of the case? Please tell the court. Yes, what are the facts?
Yes, my lord. My lord, the petitioner is the legally wedded wife of the respondent. The petitioner has filed this petition for the relief of enhancement of the interim maintenance from 10,000 to 25,000.
Hmm.
My lord,
When was 10,000 granted?
impugning order, my lord.
13th April 2023. 13th April 2023, my lords.
13th April
April?
2023.
2023.
Where 10,000 is granted?
10,000 is granted.
10,000.
Then enhancement when it is filed?
It is filed in the year 2000, last 23, my lords.
No. First order of 10,000 rupees, when was it?
It is granted on 13th April 2023, my lords. From the date of filing of petition, that is the
Then
petition
when this enhancement petition is filed?
before this honorable court.
So what he says is,
He is not, no, my lords. Actually, he has
what he is saying is 10,000 is granted, now an enhancement petition
no
is filed.
enhancement petition has been filed.
Please come to the impugned order.
Impugning.
Impugned order.
Yes, my lord. Order portion, my lord. Operative portion. The maintenance.
Where do you get that it is enhancement petition?
No enhancement.
Where from you are getting that it is an enhancement, seeking enhancement, the petition is filed?
My lord,
You said just now, you said that she sought enhancement from 10,000 to 25,000.
yes, my lord.
Where from you get that? Please come to the impugned order, Mr.
Yes, my
Counsel.
lord. That is the maintenance application filed by the petitioner is partly allowed under section 125, subsection 1 of CRPC. The respondent is hereby directed to pay the 10,000 per month to the petitioner towards the interim maintenance within 5th of every calendar month from the date of.
It's the
filing
first
of-
time maintenance is granted
Yes, ma'am.
of 10,000.
Yes,
Oh. Then according to you, before the court, she said that she's not working.
But she is not working.
Hmm.
If your lordship permit me, I will narrate the scenage of events, what happened, my lords. Your lordship may kindly go through today's my documents, my lords. First, husband has filed a petition for divorce. That is today's first page number 1, my lords.
Hmm.
That is the divorce petition filed by the husband, my lords,
Hmm.
before the family court Bandra, Mumbai, my lords,
Hmm.
in the year 2015, my lords.
Hmm.
My lords, after filing of this petition, my lords, the summons came to be served on the wife.
Hmm.
Immediately after serving of the summons, my lords, she has initiated proceedings under protection of women from domestic violence, my lords.
Hmm.
That is available at page number 16. Page number 16, my lords.
Hmm.
In the year 2016, my lords.
Hmm.
In that petition, my lords, she has claimed a interim maintenance, but no interim maintenance awarded.
Hmm.
After that, my lords, she kept quiet till 2019, my lords.
Hmm.
And the divorce proceedings was going on before the family court Bandra, and the husband has stepped into the witness box. He was fully cross-examined by the wife, and after that the matter posted for her evidence, and she was not stepped into the witness box. In the year 2015, after filing of the maintenance petition before the family court, she has gone before the Supreme Court, my lords. Your lordship may kindly come to next document, my lords. Transfer petition filed in the page number 46, my lords.
Hmm.
Page number 46.
It was allowed?
It is allowed, my lords.
It is allowed.
It is allowed. And in that transfer petition, my lords, Honorable Supreme Court held that, my lords, since the matter of the year 2015, both the parties are hereby directed to cooperate in the family court for speedy disposal. Hence, the transfer petition came to be allowed, my lords, and matter transferred from Mumbai court to family court, Bangalore. After that, my lords, your lordship may kindly come to the order sheet. Your lordship may kindly come to page number 63, my lords. Page number 63, my lords. That is the order sheet after transferring of the petition from the Mumbai, my lords.
Yes.
Page number 65. I may read relevant
portion of that. That is very important. 65, you will actually found that.
Yes.
Sri BKK advocate filed memo of undertaking for the respondent as per the directions of the Honorable Supreme Court of India in transfer petition number so and so, dated 18/5/2022. Criminal petition number, criminal miscellaneous number 793 of 19 clubbed with this case and ordered to lead the evidence in this case. On careful consideration of entire documents of the divorce petition number so and so of year 2015, wherein already petitioner of the said case has completed their said evidence. Now the said petitioner is representing in this case as a respondent. Advocate for respondent submitted that there is no evidence on the part of the respondent in this MC case. Petitioner of this case is hereby directed to lead the evidence on next date of hearing, since the transfer case is the oldest matter of 2015. After that, my lord, she was not stepped into the witness box before this honorable court. Next, my lords, next sentence. Third, an application filed under section 91, that is the 91 application filed by the husband, my lords. You will also may kindly come to previous page number 60. That is the application filed by the husband regarding she has suppressed the fact that earlier at the point of marriage.
Yes, I understand. Read it.
And 91 application, my lords, that came to be allowed by the family code.
Yes.
After that, my lords, you will also may kindly come to next page, page number 67. IA filed under section 91 of CRPC is hereby allowed. Office is ready to write a letter to the Raymond Company, Bangalore, to call for the details sought in the application for hearing on the interim maintenance application and also respondent's evidence by 17/8/2022, my lords. After that, both the next date, respondent present and filed IA under section 13 of Family Court Act and engaged the counsel by the wife. After that, my lords, next letter sent to the employer through the RPD and returned back as refused to take the RPD notice. Issue show cause notice to the employer of the respondent to send a authentic person for giving explanation regarding not issued the RPD where in order for submit the salary details of petitioner by 15/9/2022. And after that, my lord, till date, that is document is awaited and she stepped into the witness box and she was not turned for cross-examination till date, my lords. Till date. As far as, my lords, she is intentionally protracting the proceedings, my lords. My respectful submission to this honorable court, my lords. Once she stepped into the witness box, I can elucidate some important things regarding her employment, my lords. Even humanitarian grounds, my lords, I have challenged the 10,000 maintenance, my lords. Even my 91 application has not fully complied with the order passed by the family court, my lords. I have not challenged the interim maintenance. This is interim maintenance. My respectful submission to your lordship is that, my lords, let her to step into the witness box. Even, my lords, Supreme Court has given directions in the year 2020, my lords, to complete the proceedings. Till date, my lords, only she has to, her evidence is required. We have completed our evidence. This is the matter of the year 2015. For that reason, my respectful submission to your lordship is this is the interim maintenance. My lords, even if she is entitled more than this maintenance, she is having every right at the time of final disposal, my lords. My respectful submission will also may kindly give direction to the family court to dispose of the matter within 1 month or 2 months, my lords. Only her cross-examination is required. After that, arguments and after that, trial court can proceed for the judgment. For that reason, my lords, if she is entitled for more maintenance, my lords, at the final stage of the judgment, she is entitled for that. That is my respectful submission. Suppression of facts I can elicit it only after the cross-examination. She is not turned before the court. Even I am paying maintenance, my lords, till today.
My lord, the learned counsel has submitted that await report from the remand company. That is under section 91. It is still awaited, he told. That is a wrong statement. My lord, kindly turn the page number 18.
Yes.
My lord, the second para. The notice under section 91 of the CRPC issued to the employer of the petitioner is returned back dated 28/11/2022 by stating that, my lord, it is in Kannada, ನೋಟಿಸ್ನಲ್ಲಿ ತಿಳಿಸಿದ ವ್ಯಕ್ತಿಯು ಪ್ರಸ್ತುತ ಈ ಶಾಪ್ನಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿಲ್ಲ. The mentioned person is not working in the shop.
What he submits is correct or not, that you have not entered into the witness box till now?
I led the evidence, my
When did
lord.
you let
It
the
is
evidence?
set down for cross-examination. The respondent has made, drag the proceedings until passing the order of the interim maintenance, my lord. After that, he filed one or the other applications filed before the court and drag the matters. Therefore, it is delayed.
What is your salary?
My lords, my salary is 90,000 rupees, my lord. And after deductions, my lords, it is 70,000 change. And he has purchased one flat. For that, his EMI is paying. I have submitted all the documents. I have not suppressed one
So
single
after
material
that, what
fact.
is your income?
After, my lords,
After all those deductions?
after all those things, my lords, 45 to 50, I can save, my lords. Because I have only my mother, my lords, aged mother. I have no father, my lords.
During cross, one more submission, okay? Kindly turn the page number 49, my lord.
49 of what?
Document,
These
documents,
papers?
documents. During cross-examination of, I flagged it,
Yes.
49. ma'am. During cross-examination of respondent, Darshan Madalkar, here in respondent, my lord.
Where are you reading
Facts.
49?
Para number 47, my lord.
Hmm.
I have completed MCA. The house shown in address is owned by me. At the time of marriage, I was working with Wipro, Singapore. After marriage, I stayed with the respondent at Mumbai for 8 days. Therefore, I went to Singapore alone. My wife was staying with my mother. Respondent's parental house is at Karwar. I had been there at the time of marriage. My salary was 5,900 Singapore dollars per month. 5,900 Singapore dollar, my lord. At the time of marriage, it is converting into the Indian rupees. It is more than 1,91,000.
He is working in
That is
India.
at the time of marriage only.
At the time of, but still he is working with Wipro company only. How it is reduced to 80,000? He is declaring in the affidavit. It is false, my lord.
Produce the salary certificate
It's
also. along with the asset and liability.
contradictory to his own statement. It is more than 1,91,000, my lord. And also court has given findings that para number 9, my lord, order of the imputing order, para number 9, where there is clearly stated that the respondent by filing a memo stated to adopt the objections filed to the main petition as the objection to IA number 2. In the objections, he has stated that the petition filed by the petitioner is not maintainable in facts. She has filed this petition suppressing the true facts with an intention to harass him and his family members in one or the other way, just to make false him. He admits the solemnization, my lord, here in admission, court has given findings that he admits the solemnization of marriage with the petitioner and registration of the marriage. The respondent contended in para number 3 and 4 of his objection that he is a qualified engineering having completed MCA and working as software engineer
The time
in
frame fixed
Wipro
by the
company.
Supreme Court, when it has to be when it should have been completed?
My lords,
As per the time frame fixed by the
Supreme Court, my lords, speedy disposal, it is not time fixed, my lords, speedy disposal.
no
Because it
time
is the
on-
year of 2020, my lords. Since, my lords, my respectable submission, my lords, kindly give direction.
Ask the court to dispose of the
Dispose,
matter
that's it, my
within
lord.
2 months.
If she is really entitled for more maintenance, my lords, even my lords, I have not challenged because of this thing, my lords. If she is entitled, let her to take the maintenance, my
Pay
lords,
another
as per the
10,000.
merits.
Pay another 10,000 for the next 2-3 months. Then the court will decide what
Please,
is our entitlement. We'll increase it to another 10,000,
Please,
20,000 per month.
One more submission, sir. Still, he has paid 2,25,000 only out of 5,80,000, my lord.
That
He
you-
is-
Monthly I
he
am
is
paying,
not-
my lords. Yesterday was, it
No,
was there, I
no,
have paid.
he is not paying
Next
monthly,
month
my
it-
lord. He is the chronic defaulter in
That's-
payment of arrears of
That's-
rent, arrears
Have
of
a remedy if
maintenance.
he is a chronic defaulter. You can file an application before the court, you can file an EP, you have so many
I filed
remedies.
it, my lord.
Court will not deal with all that. Agreed with the orders passed in. See miscellaneous number 793 of 2019. dated 13th April 2023. The wife is before this court. Wife had filed I number 2 under section 125 1 CRPC, seeking a direction to the respondent to pay a sum of 60,000 per month, and also as maintenance and rupees 50,000 towards litigation expenses. It is a case of the wife that husband is working in Singapore and earning an amount of rupees 1,91,895. And he owns a house at Puja Galaxy worth more than 1 crore at Thane. And is earning this, the rent is getting the rental income of rupees 3 lakh per month. And one more residential house, which is ancestral house, inherited from his father. The trial court, the respondent husband had only filed a memo to adopt the main objections to the petition. The court observes that is a case of the husband that she is drawing salary of 20,000 from Raymond Company. On the other hand, no, it is stated about the, on the other hand, it is this case that is getting salary of more than 90,000. And after deduction, approximately it remains 70,000 for maintenance, for maintaining his family expenses, looking after the medical expenses of his mother and other expenses of his family dependents. The court observed that even if it is presumed that the wife is getting 20,000 income per month, since the price of essential commodities are reached to sky, the 20,000 is not sufficient for maintaining herself. Respondent being the husband of the petitioner, it is bound in duty to take care of her. Considering all that, the court had granted an amount of rupees 10,000 and also another amount of rupees 10,000 towards the litigation expenses. Land counsel appearing for the petitioner submits that when the husband is earning more than 1 lakh as salary and also is having rental income and also other properties, court has only granted an amount of rupees 10,000 as maintenance. And while granting the maintenance, court has failed to consider all these aspects. He submits that the contention that she is working in 3 months is also without any basis. And as per the notice sent to them, sent to the Raymonds, where they have stated that nobody is working with the set name. Is it so? That nobody is working with the name?
No, she is not working.
She was working, clear she was working, now she was not working, that is my land's principle.
That Kannada, what is that?
Kannada, earlier she was working, now she was not working, that is the statement.
It
She
is
left
stated
the
that
job
earlier she
8 years
job.
ago.
And now now she is not working. He submits that considering the financial capabilities of the husband and the fact that the wife is not working, the court ought to have granted a reasonable maintenance under the facts and circumstances of this case. Next, for learned counsel appearing for the respondent husband submits that the MC is filed in the year 2015 before the courts at Mumbai. And later on the transfer petition filed by the wife, it is transferred to the courts at Bangalore. He submits that while disposing of, while transferring the petition, the Honorable Apex Court has observed that as this is an MC of 2015, it has to be disposed of as expeditiously as possible. It's a case of the husband that wife is not cooperating with the trial. She is not entering into the witness box. He submits that if the wife is successful in proving that what is the income of the husband, or what, and he would be able to elicit whether she is working or not, and whether all the facts that are stated before the court are correct or not. An effective adjudication can be done, and the court would be in a position to pass appropriate orders. He submits that the trial court had rightly granted an amount of rupees 10,000 considering the about hearing the counsels on either side, there is a material on that one. According to the husband, the wife is working. According to the wife, she's not working. And according to her, is having his income is more than 1 lakh and is having a rental income of 3 lakhs and other immovable properties. According to the husband, his take-home salary is 90,000 and he has other the loans and other things to be paid. And he'll be getting he will be taking home an amount of rupees 70,000. He has a old mother who to take care of. It is when the MCs of the year 2015, even after 9 years, the same is pending. Considering the income of the husband, and as of now, there is nothing to show that the wife is earning. This court deems it appropriate to enhance the maintenance from 10,000 to 20,000. The husband shall pay the arrears to the wife. If the arrears are not paid, the matter will not be taken up by the court for final adjudication. If all the arrears are paid by the husband, within a period of 2 years from the date of clearing the arrears to the main MC itself shall be disposed of. The 2 months shall be, that 2 months will
Enhanced
start.
period only for these 2 months.
Enhancement is for only 2
Only
months.
2 paid. That means 2 months only.
This enhanced amount is for this 2 months and that 2 months will start, that period for disposal will start from the day you pay all the arrears.
Arrears, please.
Accordingly, the wife shall cooperate and no unnecessary adjournment shall be granted by the court.
That is regarding that enhancement, clarification
The
regarding
enhanced amount is till the application is decided.
from today.
From the date of order till the application is decided by the trial court. Till the MC is decided by the court.
Much
Yes.
Cell number 13. All petitioner take a petitioner.
Yes.
Chair Rajesh, ready?
Petitioner by me, filed the visitation rights, Lordship, the operation portion of order in page 25. My visitation rights dismissed by the trial court on the ground in page 25. Orders 14th. I'll read the second line. Though the child was very young at the time of incident, a statement was recorded under section 164 of CRPC. The incident of death of mother of the ward will be certainly have impact on mind of the tender age ward, and till the date he fatally refused to even see the father / respondent in this
Who has
fact.
filed this DNWC?
The grandparents and the
Uncle.
uncle,
Hmm.
they have filed. I have filed this application.
And the boy is staying with whom?
Their grandparents.
Visitation is sought by?
Fathers start by the father. Only visitation second Saturday and
Where is the father staying? Where are the grandparents staying?
father staying in Anantapur. He is the school teacher. He is residing over there. The grandparents, they are residing in Bangalore.
Hmm.
And they are taking forcibly custody of this child when he was in JC. There is an allegation that he killed the wife.
How old is he? The boy?
Now
11
years.
11 year 5 months.
When the mother died?
In the year 2017.
17.
4 year, my lord. 5 year, my lord.
Right from that time, he is staying with the grandparents.
Yes,
Yes.
madam. After death of her mother, his mother, he is staying with the grandparents.
Hmm. How she died?
Child identify the scenario of the murder, that his father hit her mother with the iron blade attached with stick.
Hmm. What has happened to the criminal case?
It is acquitted.
Acquitted, my lord.
After lapse of 6-7 days, they filed false case. The entire scenario, they have not filed at the time. When she was admitted in hospital, then she passed away. The charge sheet filed by the police.
So, right from that day, the father had never seen the child.
Never seen. They are not allowed. They are taken from Anantapur. They came to the Bangalore. And they filed GMWCT for the custody, entire custody. I filed the application for the visitation rights second Saturday and Sunday. I have not married. The entire property and other amounts I have to give my son only. I sought for only a visitation rights second Saturday and Sunday only. That also only one ground, Your Lordship kindly see. The now I read on 14th page the order, trial court order in page 25. In the facts and the circumstance of the hand, I proceed to hold that the child ward cannot be compelled to visit his father and child cannot be subject to the for father trust, taruma, agony, and when already lost his mother, young age, compelling the child to visit his father may make child to remind the incident took place in 2017 again.
But the grandparents should make some effort.
My entire property, I will give him my.
Please wait, please.
I may be permitted to page number 60 of the
Page number 16.
It's the judgment. Para number 22 of page number 60. Para
This
number,
order is only,
yes, my lord.
Interim
it's only 13 paragraphs.
But
No.
the findings, I need to convince
Which
the
you
court.
want to, which order?
I have produced a
Please wait, let him submit.
It's a order passed by us, order passed in session case number 207.
That, where is that? Where is it? Which page number?
Page number 60 at para number 22, my lord.
Yes,
Para number 22. I may be permitted to read, my lord.
yes.
At this juncture, it is relevant to consider evidence of PW8, who is son of the deceased, and A1, as according to the prosecution, PW8 is only eyewitness to the incident. His statement was recorded by learned magistrate, who is examined as PW14 under section 161 of CRPC. When PW8 came to court, give evidence by the boy stated that the accused scolded his mother and A1 beat his mother from behind his mother with a stick that has a blade. Blade was oozing out thereafter. And page number. And next I may be permitted to read page number 14 of the order, my lord.
Yes.
Yes, my lord.
Yes.
Eighth line, my lord.
Yes.
They preferred appeal before the Honorable High Court of Andhra Pradesh in Amaravati in criminal number appeal number 380 of 22, and it is pending disposal and it is still pending for disposal. The respondent filed.
Grandparents have filed an appeal against
Yes,
secretary.
I have preferred an appeal. In Andhra Pradesh also, the father filed a GNWC custody petition seeking custody of the minor child. In that case also, the child was interrogated, but the child was refused to meet his father. Again, in this case also, the court has interrogated with the child. Child again refused to go with his father. Child is a brilliant student, and after death of her mother, father tried to strangulate the minor child. I have furnished the photographs which is furnished at my objection at annexure R7, my lord. This is the photograph. Father tried to kill his son. The strangulation marks are there. Both the trial courts in Andhra Pradesh and also in this case also interacted with the child personally. Both times also, child is refused to go with his father. He is in a fear. He is a merit student, my lord.
I'll make submission. Here, there is no interaction with the child by the trial court judge. My learned friend making false allegation. There is no such. Now, Your Lordship, kindly come to the the acquittal,
Check with the boy and then we'll take a call. Not a case for any order now.
please.
The trial court had dismissed the application filed by the father seeking visitation. Then counsel for the respondent submits that the boy is not interested to see the father as he has been an eyewitness with the incident where the mother had lost her life. Considering all this court deems it appropriate to interact with the child. Was this matter on 22nd of October at 2:30, at
Please.
2 o'clock in the chambers.
Yes, my lord.
The grandparents, father and the child shall be present before the court. Yes, next.
Cell number 14.
My lord, in this case,
The appearance of the petitioner.
I received the copy yesterday, my lord. I seek instruction and
My lords, on the last date of occasion, my lords had directed me to give the list of the fee receipts that I've paid, the fees that I've paid towards the children's expenses. I filed a memo to that effect yesterday, served a copy on them yesterday.
Request of non-counsel respondent. Was this matter on 22nd October. Interim order is there.
Interim order, sir.
Interim order earlier granted is extended till then. Yes, please.
Please.
Number
Obliged.
15, Ms. Swami Gowda, SG. Sub petitioner, Arun Govind Sai.
As directed, I'm placing the CCTV footage, also some photographs.
So as per the same what it is.
My lord, only I've given the timings also, my lord, I've produced the photographs. I have not taken the child outside.
I have the video recording.
I have produced the entire CCTV footage with the pen drive itself.
Direction was to me to place the material on record. Lordship's permission. Copy. Page 8 is a letter of the developer issued in the year 2020. But there are two separate apartment premises. May I read page 8? This was the developer in the year 2020. Clarification regarding Prestige Misty Towers and Misty Towers Vista Tower. The purpose of this letter is to provide clarification regarding the right of way reserved in clause 6.15 of the sale deeds executed by us in favor of the purchasers of apartments in Prestige Misty Towers. Kindly note that the said right of way is reserved solely for Prestige Misty Towers Vista Tower being developed on land bearing old 7 number so and so, Yalanka Hubli, Bangalore North Taluk, measuring 2 acres. Other than the right of way in favor of occupiers of Prestige Misty Towers Vista Tower, there are no other common amenities between these two developments, and the right of way is reserved only through the existing driveway within Prestige Misty Towers to reach Misty Towers Vista Tower. My lord, he took the children away from Misty Towers to that Vista Tower. This is what your lordship's order was very clear. He has to stay within the area of Misty Towers. He took the children to the adjoining complex, my lord. Therefore, I had made that submission on the last occasion. Well, that is very clear from the CCTV footage. I have shown where he's driving out of the Misty Towers complex. But be that as it may, my lord, now the visitation is going on by and far. I think children are more or less comfortable. They have their good days and bad days. They're 3 years old. Therefore, your lordship may make some arrangement, my lord, for visitation on the weekends in such a way that since both are professionals, mother also gets time with the father.
I have produced my photographs and the video, this thing, my lord. My lord, for both the towers, my lord, it's only one entry and exit. For both, that is the reason I produced the plan also. Entry and exit for both this thing, it's only one.
Sorry, it's not entry and exit. It's right of way. It's like, no, it's like an
Why should it be made a big issue? It's within the premises.
No, it is not.
Anyhow, it is like, they're very much within the.
That is why I said in the heat of the moment.
If you have to have a drive, it'll cover more area so that they can have the children will enjoy the drive.
At that time, your lordship's order was very specific that it has to be in the Misty Towers complex. That is all. Now,
the whole problem is being too specific. Everything is causing the problems. Let them be little.
Now I think
the thought should be more. Should have a broader thinking.
Broader vision. Let us look at the children's welfare and then proceed.
I think already like they've been before the courts, and it's high time that they should stop coming to the court with all these kind of the grounds which are not at all no need to consider this in fact.
Outside the court, even
from the last date, we have been making hectic efforts, my lord, through a senior advocate who knows both the parties to settle the matter. Unfortunately, my other side is uncooperative. Unfortunately, this is communicated to me by the senior advocate.
Why is it not
My
working
lord, let
out?
me see. My lord, according to them, she has to go out of country and she wants to take the children out of the
I have
country.
never said that.
That is what my client has told me.
Never said that. Your lordship, I record my
Who has
submission.
mediated this matter?
A senior advocate, my lord. Sir.
Okay.
Yes.
And reduce the visitation, which my client
No, I
does
have
not
not.
agree with.
Lord, what we have said is, your lordship's order is very specific on educational expenses, on maintenance, and also the sale of the apartment. We are okay with that. We're not claiming any alimony. What we have said that whatever visitation is order is passed by your lordship, let that continue until the children are 5 years old. They're 3 years old now, twins. At 5 years old, let's revisit and enhance it when children get more. He wants, Lord, overnight at this age.
We are not asking overnight, my lord. Even my prayer itself is very specific. On alternate Saturday and Sundays, I'll take the children from 10 o'clock to 5 o'clock. I'll drop the children. That's all. That is what in my prayer.
It sounds so simple, then why it is not happening?
Lord, senior advocates communicated to me, my lord, directly that the other side is not cooperating because they're asking for 50% vacations and overnight visitation. That is where the entire settlement has.
What do you say about
Can you
it?
record this submission? My lord? I will ask the senior advocate to mediate again. Can you record this submission?
That this visitation, this thing I didn't know, my lord. What was involved to me is that she wants to go out of country, which she wants to take the children.
That they are saying that it is not the issue at all.
Take you on vacation, not permanently.
Reduce visitation and reduce money. That's what it was informed to him. Whatever the permanent alimony she has asked, reduce the amount what is supposed to be paid by the husband to the wife. And
But
also,
he wants that to be reduced.
no. That what was informed by the senior counsel to my client. You consider this and reduce the visitation
So
rates.
why don't these people appear before the Bangalore mediation center?
Not mediation.
Or we'll ask the senior advocates.
Mr. Sheila.
Yes, madam. We are ready to go for that settlement. That we are not problem.
No, because when the issue is very simple.
I am
and
not
at least-
claiming alimony.
Uh,
I don't know why my learned friend is saying that we are not claiming alimony. What your lordship says, your lordship's order, we have accepted that wholeheartedly. Lord, the visitation is where the entire issue is now stuck at.
Now, what is the visitation now?
50% of vacations and overnight.
As of now, by the order of the court,
No, your lordship said given 2 hours Saturday, Sunday.
every week.
No, my lord. What is that? That is what the trial court has passed. That is what I have challenged before
Trial
this
courts,
court.
they have 2 hours once a week.
No, what is the order of this court?
My lord, this court, there is no interim order, my lord. Your lordship has directed for a week. Let the father go and meet the children from for 4 to 6 or something. That 1 week he had, that's all. After that, whatever the trial court has passed, my lord, every Saturday or Sunday after alternate weekends, my lord, about 4 to 6 every Saturday, 4 to 6 is going and meeting the children. Apart from that, what my prayer is that, my lord, he'll take the children from 10 alternate weekends, that is Saturday and Sunday, from 10 to 5, and then he'll drop back the children. Let that arrangement be made by this honorable court, my lord, I have no problem.
Annexure J, page 89, my lord, the claim before the family court is for 4 hours visitation on one Saturday, or every Saturday. I don't know how my learned friend, my lord, coming before the High Court wants to go beyond the scope of his
That time
claim
the
before the
children,
family court, 227 proceeding.
that time the children were 2.5 years. Now the children
I'm
are
sorry.
3.5 years.
This was filed on 23rd of April 2024, 4 months ago. No, but there may be some fairness in making submissions.
That's what, my lord, 10 to 5 I'm asking. I'm not asking alternate weekends.
You are questioning an order passed by the trial court.
Yes, my lord.
Whatever you ask there,
Yes,
you
my
are
lord.
restricted
Yeah,
to that.
at least that much we begin. my lord.
You cannot ask beyond that.
Yes, ma'am.
What was that you asked before the trial court?
My lord, I've asked for the trial court before the application is that, my lord, if your lordship may kindly take the page number 58.
Page number?
58, Annexure C. Please to grant interim custody of the alternative visitation rights of the minor children, Ira and Raghav, to the petitioner during weekend and holidays in the interest of justice. That's what I've asked.
Page 89, my lord.
And thereafter, in the written arguments, what it has been stated, my friend is stating.
That is the case. That's the case made out in the written arguments, page 89, my lord.
During every weekend and holidays in the interest of justice and equity. That's
Yes.
what is the
Can you see page 89?
18 in the written arguments, my lord,
Written
considering
argument filed by
the
the
age
petitioner.
of the children,
Paragraph number 2, the present 2 hours granted in the park area where the respondent resides is not feasible. And since
No, what is happening is, please understand, now in their building, all the time, somebody or the other with a phone.
ಮ್ಯೂಟ್ ಆಗಿದೆಯಾ? ವಾಯ್ಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
that the entry and exit is one and the same to both the apartments. At this stage, this court is not inclined to go into all those issues. Both the children are now aged 3.5 years. Aged 3.5 years. The trial court's order is that the father can exercise the visitation at the mother's place, between 4 and 6. The children who are of that age, making them to sit at one place and exercising the visitation is of no consequence. No, is not at all useful for the child to develop the bonding with for the children to develop bonding with the father. It is a request is made by the land council for the father that on a Saturday, on every Saturday, the father may be permitted to take the children to his house, and they can have exercise the visitation between 10 o'clock to 2 o'clock. And it is also submitted that during the birthdays of the father and the children, and also on vacation and on festivals, in addition to the Saturdays, the father may be permitted to exercise the visitation. Land counsel appearing for the respondent submits that when they have filed a writ petition questioning an order passed by the court, now what all they are submitting before this court is beyond the scope of this writ petition. And what they are seeking is also what they have sought before what they have not sought before the family court. It is submitted that the client, the respondent mother is not coming in the way of the father. And whenever, for any reason, if the father is not able to exercise the visitation, when she is asking him to, when she wanted to compensate the same, even on that also, there is no consensus. And the respondent for the petitioner father says that he'll only exercise the visitation in the weekend, considering the submission on behalf of both the parties, and also considering the welfare of the minor children and the bonding that has to be developed between the father and the children who are of tender age. This court is passing the following order. 1, the father on Saturdays can pick up the children at 2 o'clock and drop them back at 10 o'clock and drop them back by 2 p.m. The father shall stick to the timeline, and on time he has to pick up the children and drop them back. The mother shall furnish the details of the children's food and other habits so that the father would be following the same. While the children are with the father, whatever is the life or the food habits or the other lifestyle which they are used to with the mother, the same shall be followed by the father. Next, on the birthday of the children, as well on the birthday of the father can have the first on birthday of the children, the father can take the children at 10 o'clock and that day you can have 2 hours on the birthday.
If it's a school day, then it becomes difficult.
If it is a school days, evening I'll take by 4 o'clock.
4 to 6.
4 to 6. If it is a working day, if it's a school day, if the school is working on the day, then it is between 4 and 6. And if it is a holiday, then it is between 10 and 12. Even the same has to be followed on all the important festivals. Then coming to the vacation.
Festivals, let it be between 10 to 4, my lord. 10 to 2.
For what?
Festivals.
She also has to celebrate.
Because again, traveling
He also has to celebrate.
Correct, my lord, because the traveling itself, it takes the.
No, you can't afford to ask for all this because that's not what
At
is
least, my lord, off of the day, let the children be with
the Arab and the camel story.
The half of the day, my lord, let it be.
Next, when it comes to the vacation, the father can have the the 40% of the 40% of the vacation
But
where he can exercise.
Summer vacation, it will be 3 months, then 40% would mean almost month and a half or something, because her parents stay in Patna and she travels there usually.
Let her go after that.
40%
In the remaining this.
That's what I said. Now the court will not pass any order
Yes.
because that's
No,
not
madam.
the
Sorry.
scope of this petition at all.
Sorry,
So whatever, the respondent counsel says accordingly will pass an order. Yes.
maybe about 2 weeks, not to start with,
Huh.
during summer
The-
vacations.
During the summer vacation, the father for a continuous period, for a 2 weeks time, as per the Mr. Govindaraj,
Yes.
like how it is, like on the first 2 weeks or last 2 weeks.
Let them know.
Let both of, no, if both of them can decide, they would have not been
First
before
2
the
weeks.
court.
First 2 weeks.
Yes, first, in the summer vacation, for the first 2 weeks, the father can have can exercise the visitation between, it's summer between 10 and 2. Why can't we'll make it 4 on
Yes, ma'am.
summer, only in the summer vacation between 10 o'clock to 4 o'clock. The father can pick up the child at 10 o'clock and drop him back at 4 o'clock. He can exercise the visitation for like this in summer.
Monday
The
to
first
Monday to Friday, for the first 2 weeks.
Ah,
So the
for-
Saturday, Sunday,
yes,
Monday,
yes.
can extend.
Monday to Friday for the first 2 weeks. Then everything is covered now.
My lord, no,
The father, both the parties shall not, till the father shall not come up with applications, shall not file any application till the children are 5 years old. If this arrangement is not working out, and for that, is there any, if any of the parties are not cooperating or not complying, then they can move an appropriate application.
my lord, only the Christmas vacation and the Dasara vacations have not been done.
No,
Only
we-
the
4 days, 3 days. What? my lord, we-
Dasara vacation, how many days of the vacation? 4 days?
it will be 15 days, my lord, total.
Huh?
School
First to
will be
12th, they
15.
have holidays.
First to 12.
So
Ah,
4
for the 4 days in Dasara vacation, Christmas vacation, 4 days. It should be, we'll say that on the first quarter,
Yes,
first, the immediate vacation.
Yes.
So that after that she can have the time.
Correct.
Yes.
No, for, if she's traveling out of town already pre-booked.
Whenever it is not convenient to the mother, she shall inform the
Right.
same in advance to the, to the father, and she shall compensate the same
Correct.
at a later point of time.
Obliged.
Even in case of the husband also, he
Whatever.
shall inform the same to the mother in advance. Yes. Next,
Cell number 16, DJ Simkapur, for petitioner, Ajah for respondent.
yes.
The copy, my lord.
Then what about Mr. Gorindraj? The parties shall,
Mediation.
it appears that there is a scope for mediation. Both the parties shall appear before the senior counsel, Susila. Then you can inform her,
I will communicate.
they can appear before her and appear before her. Yes.
My lord, one more submission, my last date of hearing, your lordship had directed them to furnish the details, that the father's name and phone
My
number.
memo, I've already filed the email
included in
3
the-
months ago.
No, last time it has been directed to them.
In my
Last-
memo filed
So they have
today,
given already.
copies given, sir.
No, it is not. That's what he is not
Sir,
receiving
please
any
see the
messages
email,
from the WhatsApp.
Please see the email.
WhatsApp is asking.
Please write to the school, you have the email ID.
It is submitted, no, it is in the arguments, it is submitted by the council for the, it is a case of, it is submitted by the land council for the father that he is not added in the school group, which is denied by the land council for the respondent, stating that they have already added the petition, the husband in the school group. If it is not, the mother shall ensure that the father,
He has to communicate with the school. I've already given the school all his details. He can communicate. He's been writing to the school.
the mother, it is submitted that
Yes.
he can, the mother has already communicated,
Yes.
and the father can be in touch with the school authorities.
Right.
Yes.
16, DJ Simkapur, for petitioner, Raja for
Share the copy, my lord.
Appear for respondent,
Hmm.
in this case.
What is the impugned order?
Impugned order at page number 123, my lord. At the interim
123.
maintenance rupees 4,000 to the wife, my lord.
What is your what is your income?
He is a retired employee, my lord. 30,000 is the salary, my lord.
13.
Yes, sir.
Ah.
30,000, madam.
30.
The date of the marriage is, my lord,
No, 30.
30, madam.
Then what is the difficulty to pay 4,000?
My lord, kindly, date of the marriage is 35/1994, my lord. In the 2002, from they are disputed between both the husband and wife, my lord. She filed a criminal miss number 97 of 2003. Wife, 2 daughters, my lord. It is at page number 29, my lord. Order 1,500 is granted to the both the daughters, my lord. And the wife is not entitled for any maintenance. That is the order, my lord. In the 2003, kindly peruse the page number 29, my lord.
Why she is not entitled?
She is working, my lord.
No, she is working at that point of time.
As
No, another application is filed stating that she is in need of money. So just because an order is passed at that time, you can't say that she is not entitled.
1
now.
minute, my lord. Thereafter, my lord, in the 17/4/2002, the husband is gifted the property, my lord. She is in the possession of the property. Thereafter, they filed the RPFC number 22/2011, my lord, for enhancement of the maintenance, my lord. Before this honorable court. Honorable court enhanced the maintenance to 1,500 to 5,000, my lord, with a liberty to approach the trial court wherever the enhancement is required, my lord.
No, they have
Thereafter,
approached.
my lord, thereafter also, my lord, as per Annexure C, my lord, C miss number 429 of 2016 is filed. In that, my lord, 12,000 is granted each to the daughters, my lord. Thereafter, my lord, RPFC number 82/2018 is filed, my lord, 12,000 reduced to 10,000, my lord. Thereafter, my lord, the husband is paying the maintenance towards the daughters, my lord. The order in C miss number 97/2000 till date not challenged, my lord. And also in the RPFC number 22 also, if it is challenged, my lord, this honorable come to conclusion that she is not entitled for maintenance, my lord.
No, what are you
Thereafter, my
saying?
lord,
If she had challenged, that would have been an order.
RPFC.
yes, my lord. Yes,
You are anticipating that that would be the order.
my lord. She's challenged, my lord.
Where is that?
22, my lord. RPFC.
Page number?
Number 31, my lord. 31, she is also petitioner number 1, my lord. Petition number 2 and 3 are the daughters, my lord.
Where is that? The court said that she's not entitled for maintenance.
Learned counsel appearing for the response submitted, the respondent will pay the entire arrears of maintenance payable to the petitioner to in 3 installments within 3 months today. The submission placed on the revision petition shall disposed of in the above terms in modification of the order impugned herein.
I'm not able to understand that from this order, what you're submitting. I'm not able to understand what you're submitting from this order.
My lord,
Where did the court say that she's not entitled?
is filed challenging the orders in C miss number 97 of 2003.
We'll have it after vacation. Post this matter
My
after
lord,
vacation.
my lord, I make one submission. Kindly vacate the stay order, my lord. Only 4,000 was awarded. Yes, misstated this time of court, stating that he is paying the maintenance to the
Then
daughters.
we'll have it on first, not today. Yes, force this matter on first.
Interim order fairly extended.
Interim order earlier granted is extended till then. Yes, next.
Seal number 17.
I represent the first respondent in both the appeals.
This case,
Yes.
brother, there are 2 appeals. Arrears out of common orders passed on IA number 1, 2 and 7.
IA number?
IA number 1, IA number 2,
Hmm.
and IA number 7.
There is
Well-
only 2 appeals before this court.
Yes, madam.
Arising out of IA number?
IA number 1 under 13 1 and 2. IA number 2 under 13 1 and 2 filed by the first respondent plaintiff in OS number 4832/15. Then, my lord, in the same case, said case, the appellant being defendant number 5 filed an application under 13 1 and 2 seeking injunction against the plaintiff first respondent.
No, before we go into that, MFA 5532, what is IA?
That is IA number 7, madam.
2.
IA number?
IA number 7.
Hmm.
In 5531, my lord, it is IA number 2.
And so far as IA number 1 is concerned, my lord, there is no challenge.
We have
Yes.
considered not to alienate.
You have considered, yes.
Yes, ma'am. Now,
Please
madam,
come to the order.
MFA 5531, madam.
55, 30,
31.
give that one. Yes,
It is, my lord, seeking setting aside the impugn order passed by the Honorable Trial Court dated 5/4/2017 on IA number 2, my lord,
yes.
and seeking dismissal of IA number 2 by the defendant number 5 appellant hearing. Where, my lord, the gist of the facts is that the second respondent with the first dependent in the shed suit, she was allotted a BDA small site, my lord, on 26/12/77. Then, my lord, BDA entered into lease cum sale agreement in her favor on 23/7/1980.
Yes.
Then, my lord, on 29/4/2015, BDA executed an absolute sale deed in favor of dependent number 2, dependent number 1, respondent number 2. Then, my lord, the plaintiff, the first respondent herein, who alleged to be entered into a sale agreement, GP and affidavit on 11/7/1994, where, my lord, second respondent being first dependent, Alati, she was not at all having any right to enter into any contract in terms of the lease cum sale agreement. Then, my lord, both parties kept quiet, kept mum for long period.
You are the owner of the property, defendant number 1.
Yes, my lord. Dependent number 1 was the Alati from the BDA, and she was got the sale deed on, my lord, 4/5/2015.
Yes,
Then, my lord, she got executed the sale deed in favor of appellant hearing on 4/5/2015 for consideration. As, my lord, the first respondent plaintiff, my lord, he has not paid the sale consideration to the first dependent and her children. And thereby, my lord, the fifth dependent herein with the appellant herein, who paid the rest of the balance consideration to the BDA and got the sale deed in favor of the Alati. Then, considering the same, my lord, the Alati, the first dependent / respondent number 2, got executed the registered sale deed on 4/5/15. In that sale deed, my lord, she passes symbolic and constructive portion in favor of the appellant herein. The thing is, my lord, the first respondent plaintiff contending that I was put in possession on 11/7/1994 under the sale agreement, and the respondents 2 to 4 have executed the registered GPA and affidavit, and thereby is in possession. Then, my lord, after I purchased the property, my lord, the plaintiff has filed the suit in OS number 4832/2015 on the file of the Honorable Judicial 7th National.
so as on the day when you purchase the property, the plaintiff is in possession of the property according to you.
Plaintiff was in possession. He was collecting the rents on behalf of the
And he's
respondent number
also,
2.
he's also residing in one of the floors.
Yes, my lord. It is not in dispute also, my lord. Then, my lord, he filed the suit for performance of the contract against all the dependents, 1 to 5, including me. I am the 5th dependent. Then, my lord, he filed 2 applications. One is for not to alienate the suit scheduled property. Another one is not to interfere. Wherein, my lord, I appeared before the court and I considered I will not alienate the property during
But
pendency
I
of
number
this.
1,
Yes, my lord.
yes.
Then, my lord, I have also filed an application because
Seeking injunction against it.
injunction against the plaintiff, he shall not come into it to take possession from the tenants. Then, my lord, I have filed an HRC petition before the Honorable Small Cause Judge at Mehal in HRC number 10,024/16, wherein, my lord, the plaintiff, he desires to implead himself as one of the respondent. The Honorable Small Cause Judge was pleased to dismiss the impleading application. Then, my lord, the said petition came to be decreed against the,
Now, in his suit, you can seek injunction.
yes, my lord.
Yes.
Thus, my lord, after filing up the objections and counter objections, my lord, the honorable trial judge was pleased to heard the matter in length. Then, my lord, I would
That,
like to take my lordship to findings
Even judgment. with regard to this.
in ink page
If you can maintain
30,
an
my lord.
Injunction.
Para 16,
Defendants, plaintiffs, defendant. Yes,
para 16, my lord.
yes, yes.
Short point involved, my lord. The learned judge come to conclusion that plaintiff is in possession in respect of suit property by virtue of the sale agreement as he has collected the rents on behalf of the respondent number
No,
2.
it is like this. First is, IA number 1 is not to alienate.
Yes, madam.
That you have filed your, then
Yes,
second is, your IA inject, what should be done? How we should be, what is the injunction you are seeking?
I am seeking not to interfere, to take possession from the tenants. Because I got filed the HRC suit and I got in the suits,
This is IA number 3,
I number 7.
IA number 7.
7.
Court has dismissed it.
Yes, madam. Allowed 2 applications of the plaintiff and dismissed my application number 7. I would like to take my lordship to ink page 30,
No.
16, madam.
As of now, he is in possession of the property. According to him, he is entitled for the specific performance.
Yes, ma'am.
Unless and until that is decided by a full-fledged trial.
Complaint. Yes,
How can you ask for injunction? Restraining him from interfering where
That's
he is
what-
in possession.
That's what happened, my lord. Now the matter now shut down for further class of PW1. PW2 to 4 has been fully cross-examined. The rest
As
of,
a suit of 2015 will direct the trial court to dispose of the matter.
yes, please, madam.
Yes, please come. Agreed with the orders passed in. I number 2 and I number 7 dated 5/4/2017. The defendant number 5
Yes, madam.
is before this court. The respondent, the first respondent herein, who is the plaintiff in the suit, had filed, OS number 4, had filed the suit speaking specific performance of an agreement
Dated 11/7/1994.
seeking specific performance of an agreement of sale dated 11/7/1994. It is the case of the plaintiff that he has entered into an agreement with the first defendant. And he
Agreements with the defendants 1 to 4.
1 to 4.
1 to 4.
1 to 4. And they've executed a lease cum lease cum sale agreement. And they have put in, the plaintiff is put in possession of the property and the defendants have released the entire sale consideration. As per the agreement, the defendants 1 to 4 were required to pay provisional installments every month apart from provisional service charges to the authority. A registered general power of attorney dated 11/7/1994 was executed. And ever since, the plaintiff and his family members have been in possession of the property even prior to that agreement also, another agreement of sale was executed by the very same defendants 1 to 4 in favor of the plaintiff in respect of the property, and the same has merged with the present agreement of sale. The plaintiff has been paying the taxes in respect of the property. It was understood between the parties that the time was never the essence of the contract. The building consists of 3 floors. That is ground first and the second floor. In the ground floor, there is one residential unit and one a commercial shop unit, and each of the said units have been provided with separate electricity connection. And there is a tenant in the said premises and has been paying monthly rent to the plaintiff. In the first floor, the plaintiff used to reside along with his family members, and subsequent to the plaintiff shifting to the second floor, the first floor portion has been let out to letted to another tenant. In all, there are as many as 4 electricity meters, and each of the respective occupants have been paying monthly consumption charges to the respective department. Except the second floor where the plaintiff is occupying. All the other tenements have been let out on rent by the plaintiff. In spite of having the entire sale consideration, the defendants have not executed the sale deed in favor of the plaintiff. And whenever he asked them, they were assuring that they will execute the sale deed. During January 2015, the plaintiff had visited the office of the Bangalore Development Authority, inquired regarding the status of the sale deed to be executed by them in favor of the plaintiff. And the plaintiff was informed that steps are not taken to execute the sale deed. However, on 15/5/2015, the 5th defendant appeared near the property and started claiming that he has become the owner of the property and that the plaintiff and his tenant should hand over the portion of the property to him. Thereafter, the plaintiff had come up with the present suit. Initially, what was the injunction that is granted initially, IA number 1?
Not to alienate.
Not to alienate.
Initially, the court had, the IA number 1 is allowed, and the court had passed an order not to alienate. Thereafter, the defendants have filed their written statements. Defendant number 5 in whose favor the defendants whose favor a sale deed is executed, has undertaken before the court that he will not alienate the property. Then coming to IA number 7, that is filed by the defendant. Defendant number 5. What is that? Where is that IA? Page number?
IA not produced.
IA number 7 is filed.
Yeah, that's sought against the plaintiff, restraining the plaintiff from taking possession of the ground floor and first floor of SSP.
IA number 7 is filed, restraining the defendant, restraining the plaintiff from taking possession of
Ground and first floor.
ground and first floor. The trial court had made the injunction absolute in favor of the plaintiff. And when it comes to the IA number 7, the court had dismissed the same while rejecting the application of the defendant. The court observed that the 5th defendant has only constructive possession of the property and has to recover the physical portion under due process of law from the plaintiff. Since the 5th defendant has no physical portion of the suit scheduled property, question of granting an order of temporary injunction in his favor with respect to the ground floor and first floor portion of the property does not arise. If an order of temporary injunction is granted, there are possibilities of the defendants further alienating the suit property. This will cause unnecessary hardship to the plaintiff apart from multiplicity of proceedings, the court felt that there is balance of convenience in favor of the plaintiff, and accordingly, an injunction is granted. Injunction is granted. Aggrieved thereby, the appellant is before this court, filing the two appeals, MFA 5532 and MFA number 5531 of 2017. Land counsel for the appellant submits that the defendant 1 to 4 have executed a sale deed and he has been put in constructive possession of the property. Now, he being the owner is entitled to have the possession of the property, and the plaintiff, without any manner of right and title, has been collecting the rents from the defendants as such, from the tenants. As such, he has filed an IA number 7. Land counsel submits that without any basis, the trial court had dismissed the application filed by the defendant and allowed the application filed by the plaintiff. It is submitted that the court ought to have considered that unless injunction is granted, the defendant number 5 would be put to irreparable loss and hardship. Next para. Land counsel appearing for the respondent plaintiff submits that the defendant is also admitting that the plaintiff is in possession of the property. His possession cannot be disturbed, nor there can be an injunction restraining him from, there cannot be any injunction restraining him from his peaceful possession and enjoyment of the property. It is submitted that the defendant in his suit cannot seek any injunction without there being any counterclaim. It is submitted that the trial court had rightly considered and dismissed the suit. Dismiss the application filed by the defendant. The next para. This court, having heard the counsels on either side, there is the material on record. The suit is filed seeking the relief of specific performance. Admitted facts in this case are the plaintiff is in possession of the property. It's a case of defendant number 5 that there is a sale deed executed in his favor by defendants 1 to 4, and he has been in constructive possession of the property. And he wants an injunction restraining the plaintiff from interfering with the ground and first floor of the properties. When the defendant himself, for defendant 5, is not in possession of the property, and when the plaintiff is in possession of is in fact in admitted possession of the property, question of granting injunction against the plaintiff will not arise. The trial court had rightly considered the fact and held that the balance of convenience and the irreparable loss are in favor of the plaintiff and not on behalf in favor of the defendant, and had rightly dismissed the application filed by the defendant and allowed the application filed by the plaintiff. And this court finds no reasons to interfere. Next, accordingly, this court is passing the following order. The MFA is MFA number so and so is dismissed. These suits are of the year 2015, and this court deems it appropriate to direct the trial court to dispose of the suits within a period of 6 months from the date of receipt of the copy of the order.
Grateful to the court.
That you keep
That's
it.
okay.
Yes, next.
Cell number 18. Chansraj KG.
Who moved the memo? They who moved. On a memo moved by the appellant, the matter is listed today. No representation for the appellant. Pose this matter on 22nd of October. Yes, next.
Cell number 19.
This is for admission. Trial court record is received.
Mhm.
Therefore, it may be listed on some other day. There is another matter listed in serial number 49 that is adjourned. Therefore, on the same date, it may also be adjournment, seems.
No
Because I have
representation-
moved this matter, of course.
No representation for the for the respondents. Then counsel for the appellant submits that already connected matter.
It is not
listed at-
admitted.
Huh?
It is not shown as admitted.
Connected matter is,
Not
listed
similar
at-
matter,
huh?
not connected matter, similar matter.
a similar matter is listed at
Serial
item
number
number?
49.
Huh?
Today's listed.
Serial number?
Serial number
39,
49.
49. Post along with that.
MFA
on-
six
post
eight
along with
five
that
four.
On 22nd of October.
Which date? Date is given 29/10. it says.
29th is, 29th of
29th.
October. Yes.
Serial number 20. Serial number
The
20.
appellant.
For respondent, my lords, in the
Shankar Rao,
morning, we
Vijay
have filed the
Rao.
wakalat. The copy of
Today
the
you
petition.
file.
My lords,
2022 matter.
my lords, may have it after vacation, immediately after vacation. we will-
I'll object, my lord. Your lordships recollect, this is the same matter, my lord, which I withdrew last week, my lord, because there's an
Hmm.
earlier. So they're aware, they filed objections.
My lords, it was withdrew on 20.
Is an interim order in this?
No, my lord. That's
My lords, there
Look
is
at
no,
it, if it's a case for interim order, we'll grant and adjourn.
Yes,
my lords, there is no interim order, there is no.
all the
urgency,
properties
henceforth,
are the
ma'am.
mother's.
Have this matter right immediately after the
Submitted
vacation,
with
we'll
an
file our
advance for the
details
respondent
objection.
that
to
they have
this.
filed the wakalat yesterday,
My lords, today morning. we
today
have filed.
morning, they have filed the wakalat.
And the copy of was served day before yesterday along with.
The copy is served a day before.
Friday.
At the request that this is an appeal of 2022. Learned counsel submits that, the stay application has to be considered as an appeal of 2022. As,
My lords, there is no stay
as there is
application.
no
we have been-
urgency now, post this matter on 28th of October.
Lord, may I request, my lord,
Serial number
before vacation.
No, before vacation, not possible. 28, yes,
serial number
Or-
21.
May I request for immediately after vacation?
14,
Great.
yes.
Serial number 21. Mayana Gowda for petitioner appellant. Harish A.S.
Advocate is not well.
Now, what has happened now? The clients are coming to the High Court and representing as if like this is a trial court.
Even for the first time, even there is.
No, very
practice here-
strange,
There is
yeah.
a practice here. I don't know why their advocates have asked them to appear. Even
No
I have
representation.
not seen when they before.
No representation, you have, stays there.
There is an interim order.
There is no representation on behalf of the respondent. No representation on behalf of the respondent. Post this matter after vacation on 29th of October. The interim order earlier granted is extended till the next date of hearing.
Serial number 22. The Chudia for appellant Nitin Prasad.
Actually, they were there that day itself, it seems, but they have not put up that.
Oh, okay.
Yes. Where is the trial court record? The suit. Suit is decreed on 22/1/2010.
Yes. Yes.
I think to understand this, we should only call them who wrote this.
No, I have gone through the impugned order.
Uh-huh.
Till the records are found. Would your lordship kindly have a look at para 10 of the impugned order, page 35, running page 35.
No, you're referring from the.
The current, my MFA. Please take up the MFA. In MFA, page number 35.
Page number 35.
35, where your lordships will find para 10 of the impugned order. In the miscellaneous application which I filed before the trial court had to have examined whether I had a sufficient opportunity. That is what the law requires, Order 9230. Please let us see, my lord, whether the trial court has satisfied itself about the sufficiency of the opportunity. In para 10, my lord, there are only two sentences with the trial court says. This court gone through exhibit P2, which is the order sheet. In the order sheet P1 dated 2011-2008, there is an office note that court notice to plaintiff number 1 and 2 served on person and court notice to defendant served on office. After calling out the defendant number 1, his absence was recorded in the order sheet and the court gave direction to the plaintiff to take steps against defendant number 2, which is the union. Here it is important to note that in verification portion in the pleading of this petition, it is verified by Bhaskar Reddy, the defense estate officer, that he is also representing. So right here, the trial court is drifting into the issue of whether Bhaskar Reddy as the defense estate officer had a right to represent the defendant number 2 as well, Union of India. The satisfaction that I was served, D1, that is the defense estate officer, is only found in these two sentences. The office simply says it doesn't refer to any record. Now, there is no record in which any signature of a competent officer along with the seal of the first defendant is found anywhere in the record. If it was sent through the postal department.
So like in between court has drifted from that and then come to para 11.
Yes, Lord, I'll take your lordship. Then rest of the para 10 is about that issue of the authority of D1 to represent D2. Para 11. As on 17/12/2008, the next calling date in exhibit P1, there is an office note stating that the court notice to advocate for defendants returned, put up with the file. In this regard, this court gone through the cross-examination of PW1 and page number in page number 10, PW1 has admitted that, and then, my lord, I will explain later, and at the bottom in English says, and in the same page of the deposition, he has admitted that they had verified the order sheet of, this is all deposition of the party, not of the counsel, the order sheet of the original suit. Prior to filing of this petition, it is admitted by him that the same counsel represented in OS number 7613 of 1992 and RFA number 546 of 2001. It is admitted by him after confrontation of the judgment in RFA number 545, which is marked through exhibit R1. In this regard, this court gone through order 3, rule 5. Now, I'll pause here for a moment. What is stated in para 11 is the court has established that it is the same counsel who represented earlier in the 1992 suit as also the RFA. But there is nothing on record to show that that counsel was served. Now, please have a look at why the court is referring to order 3, rule 5. It extracts order 3, rule 5. If I may read rule 5, it says any process served on the pleader who has been duly appointed to act in court for any party or left at the office or ordinary residence of such pleader, and whether the same is for the personal appearance of the party or not, shall be presumed to be duly communicated and made known to the party whom the pleader represents, and unless the court otherwise direct, shall be as effectual for all purposes as the same had been given to or served on the party in person. There is no difficulty with the law. What the law says is, if there is a counsel who is representing a party, if the notice is served on the counsel, it is deemed to have been served on the party. But the question is, does the court satisfy itself that the notice pursuant to the remand was served on the counsel? There is nothing. It simply extracts rule 5. My lord, I'll read the rest of the order. Para 12. Including the above provision as per Karnataka High Court Amendment Act, substituted by so-and-so, and then it refers to substituted provision. Then page 39. Therefore, Service of court to the petitioners is sufficient service of notice stroke summons as per law itself. Moreover, in the operative portion of R1, it is specifically directed by the Honorable High Court as under. The appeal is allowed, impugned order dated 24/3/2001 passed by so-and-so judge in so-and-so OS is set aside. Matter is remitted to court below for fresh disposal after giving opportunity to both parties to adduce their evidence. The parties are also permitted to produce additional evidence as exhibits. The court below is directed to dispose of the matter within 6 months from so-and-so. Then until here, the court refers to the law, the court refers to the deposition that it was the same counsel, but nowhere it records any finding that the court notice was served on the counsel. If
Para 13.
I will read now, para 13. Therefore, there is a direction for the disposal within 6 months from the date of the receipt of the order. Even though the same counsel appeared in the trial court and appellate court, even after service of court notice, has not come forward to appear before the court to assist the court for speedy disposal. Thereafter also, this court directed the plaintiffs to take steps on defendant number 2. My lord, I'll pause here. Now we are going into defendant number 2. Although it says that notice was served, there is no notice served. The court record says that notice sent to the counsel has returned back. So therefore, my lord, two things. Number one, there is no evidence to show that the court notice was served on first defendant DEO. There is no signature with office seal as an acknowledgement. Number one there. Number two, assuming that Order 3, Rule 5 has to be pressed into service, there is no evidence on record to show that the counsel was served. Of course, the same counsel represented before the Honorable High Court also. But pursuant to the remand, was that counsel served? The answer is no. Then the court drifts into 6 months requirement. Although it says that it is served, there is absolutely no evidence that it refers to. Then it goes into referring to how defendant number 2, Government of India, was served. So therefore, my lord, there is absolutely nothing in this order which shows that D1 was served either directly or through its counsel. Therefore, my lord, this order does not satisfy the requirement of providing sufficient opportunity to me. And on these two grounds alone, it is liable to be set aside and opportunity should be given. Making hazy references to just a bald reference to the law without referring to the actual evidence on record as to how the counsel was served. If the counsel was served, the court should have referred to the document. There is no such reference to the document. And even in para 10, other than the note in the order sheet, which says that the D1, I have gone through that order, it says court notice to defendant returned, it says. And below that it says served on office. Lord, that order sheet dated
Office is referring to D2.
Which one, Lord? No, D1.
D1 only.
D1.
That is dated?
My lord, order sheet dated 20th November, that is 2011-2008.
2011-2000.
If your lordships are looking at the order sheet of OS 7613, in that, kindly turn to order sheet, my lord, on top your lordship will find.
You said what is the date?
20th November. 20th
November 2008.
Lord, there it says C/N, that means court notice to plaintiff number 1 and 2 served on person. Below that is where I figure. Court notice to defendant 1. It says RETD should have been returned.
Served on office.
Then it says served on office. So we don't know what exactly it means. If it was served, then my lord,
probably it is served on office.
Served on. For this, my lord, my respected submission is there is no record in the trial court records. There is no evidence of yes, an acknowledgement. An acknowledgement with the seal and signature of the office of DO is not found.
So this is the only reference with regard to the defendant number 1.
Yes. Defendant number 2, my lord, they have taken out some public notice. My lord,
then where do you get with regard to this advocate for defendant number 1?
Nothing other than the impugned order, there is nowhere else.
Date.
No, the reference is there, but there is no evidence as such.
What other evidence is required?
No, of course there has to be evidence.
Oh, the
One minute. I don't know what my learned friend is submitting. In our language, service means there has to be a document. There has to be an acknowledgement by the counsel. Now, where is that acknowledgement? I have not found in the file. The court should have said This is the acknowledgement which the council has received. Obviously, any advocate will receive it by affixing his signature, seal of his office, and the date on which he has received. That document is not there in the record. In the absence of that, how did the trial court come to a conclusion that the advocate is served?
2011-2008 endorsement that it is served on the office. For that also, there is no
No.
acknowledgement.
The seal and signature of the competent officer of the defense estate officer is not there in the record.
I will verify, my lord. I will verify. My briefing counsel says that she has verified in the trial court. It is
No, because
there.
the entire record
It is there.
No, please verify. I mean,
No, if it's.
Let me not
No,
make any submission.
if it is
without
not there,
verifying.
then.
no, I'm sorry. I am making the submission after verifying.
Yes.
The
Let
seal
him-
and
let-
signature is not there. If
let-
you want time, you please verify. But don't say that submission is being without verification. My colleague Chandrachud has seen it twice. Just now, about half an hour back and in the morning.
We will-
Just
And I'm
have a
doing
look
this.
at it.
If he wants to verify, I mean, I have no difficulty with it.
No. Madam, the point is, the judgment was in 2000. The matter was remitted back to the trial court in 2008.
Hmm.
2008.
It was
Madam,
decreed on 2010.
Until 2012, the appellant will not care to go and see what has happened. That itself is negligent.
That is altogether different. My lord, that is an altogether different issue.
No. When is the order passed by the trial court?
By the trial court.
2010.
That is in the miscellaneous matter.
Miscellaneous matter, my lord, the impugned order.
Hmm.
Impugned order is 25th September 2023. The order which is impugned before my lord is
And MFA is
25th
filed in
September.
2024.
I'm sorry, my lord.
MFA is filed in 2024.
MFA ಯಾವಾಗ file ಮಾಡಿದ್ರಿ? 28th February 2024. ಆಗಿದೆ. There was some delay, it is condoned.
It's all right.
5 days delay.
Records speak for themselves. And the Honorable Supreme Court has said.
But unfortunately, right from 2010-11 till 2023, that application is not disposed of.
Yes.
Generally, in all these kind of cases where there is not much delay, court should condone it and dispose of. Should
My
hear
lord,
the
I have
matter on
appeared
the
before
merits
Honorable
of it,
Supreme Court in these kind of matters.
No, no, no,
20
no.
years later, their lordships have settled it and said, we give paramount importance to opportunity, full opportunity.
No, what I observed is from this couple of months, as far as Karnataka is concerned, on this Section 5 petitions and on this miscellaneous petitions, little like more technical approach.
Yes.
More technical.
Shouldn't be,
approach.
my lord, but shouldn't be.
Have to be.
Parties should be heard on merits.
Correct. How you, we can't lay down the red carpet for you to come to the court.
No.
But
I
in
don't
this-
need any of your carpet.
Not in this case. Generally, like for example, within now,
It is my right to be
within
heard.
even before 30 days, even within 30 days, when an application is filed, showing some reasons, like I can understand if it is inordinate delay. Immediately, if it is filed, it should be because
No, no,
there should be a
there-
full and final
Yes, the
settlement.
council also should not object. But now, your lordship will have
You
it,
can
sir.
have a look at the file.
Yeah, we will.
Yes,
Today,
yes, you can.
today or tomorrow, can you see it? Tomorrow?
Because now it is available. In the section, they will not give you to.
We will inspect.
During
the
the course, you can have it.
officer,
During the
but
course,
would your
during the
lordship
course of
have
the
it
day,
on Monday, my lord?
we'll have it.
Monday.
During the course of the
Yes.
day, you can have it, but
Yes.
not tomorrow. During the course of the day, the counts for the
Yeah, my colleague-
respondent,
because she has-
respondent is permitted to look at the records and make the submissions on Monday. Heard the council, heard the chief. Yes, in part.
Hmm?
Yes.
Yeah,
Monday.
you can see it right now.
Huh?
Or you can come at 2:30 and see. Yeah, I can also see it.
Yes.
Yes.
Cell number 23. Vishwanath
Thing for,
Shetty.
Colin Mellon, it has been taken after vacation, Mellon. They are not keeping well.
Hmm. No stay? No stay in your
Stay
favor?
is there, Mellon. They have undertaken that they will not participate with the matter before trial court, Mellon, execution court. Mellon.
That hundred should not be taken.
He wants after
No,
vacation.
I have no objection after vacation.
At the request of Land Council, the appellant
Date
posed
will be
this
given.
matter on 23rd of October and the earlier undertaken given by the, so and so. That order is extended till the next date of hearing.
Much obliged, Mellon.
23rd.
Number 24. 24. Muralidhar HM.
Yes,
This is plaintiff's appeal,
yes.
suit for injunction,
Suit for?
suit for injunction.
Huh.
IA number 1 is rejected for temporary injunction. It's rejected. That is how I am before my lords. Plaintiff, that is appellant, is a house building cooperative society.
Appellant is a
House building cooperative society.
society.
Yes. Large extent of land was acquired by the government for public purpose. That is for formation of layout and allotment of sites to its members. And the layout was formed and the members are allotted site. Everything is over. In the year 2004 or so, certain extent of land was acquired for railways, that is defendant, for expansion of their project, because the railway line runs beside or adjacent to this layout. All right. The acquisition process was over. Certain lands were acquired, possession of which was handed over to them by drawing Mahajar and the sketch. Compensation was not satisfactory. Reference was made, reference was allowed, and the compensation was taken, and they put up their boundary stones also for the acquired area. But they did not do any work for a long time. Nevertheless, the boundary lines were marked. We did not do anything within that. Now, all of a sudden, in the name of expansion of the railway project, they are coming to the land beyond what was acquired. There I objected for the same. They showed before the trial court some joint survey conducted by them saying that additional extent of land is also required for them. Therefore, they are carrying out the work. I said, no problem. You acquire and then come on the property, because we have formed the layout and the lands are provided for civic community area. You can't come on the property on the basis of the joint survey conducted for the purpose of additional requirement. At that stage, I went before the court. The notice was ordered and the railways entered appearance and produced.
What is their case?
Their case is that they are within the area and the only document placed on record was the joint survey conducted by them. My lords, kindly turn to
Joint surveys, that is, you are also present.
No, I was not present. It was conducted by railways with the land record, the director of land records, that is surveyors. It was not.
When was it before filing the suit?
Before filing the suit, it was conducted and I was not aware of. Now and they also refer to one order passed by the estate officer under Public Premises Eviction of Unauthorized Occupants Act to say that they have constructed the building and the building is within the acquired area. There is no dispute about it. If it is in the acquired area, we have no say. We are only concerned with the suit schedule property where they are doing some civil works, which is not an acquired area.
Which they are denying.
Which they are denying. Therefore, in the circumstances, a joint survey needs to be conducted and a survey report shall be placed before this honorable court. If it is within the, because extent of land acquired is not in dispute, the sketch is not in dispute, payment of compensation is not in dispute, whether the work they are carrying out is within the acquired area or beyond is the question to be decided.
We'll issue notice.
Please, my lords.
Notice to
And
the
may I
respondent.
submit, my lords? During the pendency of the suit, though there was no written order as to the maintenance of status quo or injunction, there was a oral direction by the court not to do anything, not to take precipitative action and go ahead with the work and all that. After that, this order is passed.
We'll have it on reopening day. Post this matter on 14. The counsel for the appellant is permitted to take out notice on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. To that effect by 14, list this matter on 15.
May I submit, my lords? Shall I come back on Monday after serving copy on the other side? Because they are putting up the compound wall on my property. There is some urgency and I am aware that
Unless they are represented, we cannot in these facts and circumstances. So that's better let it come out.
no, the council representing them will definitely appear. my lords. If I serve
Well, if you can post on first, by
first,
the time we shall take hand summons on the council appearing for the, by the time post this matter on Monday. By the time, the counsel for the petitioner shall take hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. Yes.
Please.
Till number 25. Ramesh.
Lord, I
Yes,
appeal
yes.
for the appellant in this matter, my lord. In this matter, my lord, the plaintiff has filed the suit for partition, my lord. Partition is filed. And in spite of the interim order passed by the trial court, my lord, the defendant, first defendant has alienated a portion of the property. Thereafter, my lord, I made an application, my lord, under Order 39 Rules 1 and 2 CPC, not to alter the nature of the properties. But the trial court, since the purchaser is not made as a party to the suit, trial court has rejected application. Your lordship the other day heard, and I made a submission, my lord, I may be put in liberty to make such an application, my lord, after impleading the purchaser. That is why, my lord, your lordship directed me to serve the copy on the
I have no objection.
counsel, my lord. I have done it, my lord.
We'll pass order in the afternoon.
Please.
I represent only the respondent numbers.
We'll see in the afternoon.
Oh, okay.
Yes, get it.
Submitted to serve the hand summons. If hand summons and the counsel appearing before the trial court. If served, post this matter on 39. ಅದು 1410 ಹೇಳಿದ್ರು ಸರ್ 1410 ಆಮೇಲೆ if hand summons memo is filed to that effect on or before 1410 ಅಂತ ಇದು ಬೇಡ ಇದು issue notice to the respondents and the learned counsel for the petitioner appellant is permitted to take out hand summons. First complete.
Hello, court? Hello?
230.
30 list. Cell number 1. Raju is.
Kindly pass over, Mala. The senior is held up in other court, Mala. Kindly 10 minutes, Mala. 10 minutes.
Every time they are asking.
No, Mala. He is held up in other court. That is why, Mala. 10 minutes,
Can
Mala.
it specifically 2:30 again another passover?
No, Mala. Sorry, Mala. My apologies.
They have a stay in this.
Yes,
This end of the list.
pass.
Cell number 2.
I'm sorry, Manoj, on the last day, not able to appear before this court, we end up in another court. Petitioner.
What is the latest salary slip?
My lords, the
How much is your
net
salary?
salary is 52,112.
Hmm.
My lords, the petitioner has got aged parents and he is also looking after his son, my lords.
Hmm.
So the trial court has granted 20,000.
So you're getting 52,112. What did you submit before this court when the matter came up for admission on the
That
date
is-
of first hearing?
My lords, before the trial court.
And counsel for the petition, the husband is getting salary of rupees 31,218. Is it not a false submission made before the court?
Because that was produced before the honorable trial court, my lords, at the time of hearing of the IA for interim.
No, you have made a statement before the court.
Please, my lords.
Basing on that, an interim order is granted.
Lords, on the basis of the document produced before the honorable court, trial court, my lords, I have made the submission. Now, the recent salary certificate reveals that.
So you can pay 20,000. We'll dismiss it on the ground. Yes, please. Agreed with orders passed in. I number 2 and C miscellaneous number 91 of 2023. Dated 26/12/2023. The husband is before this court. The wife had filed an IA seeking interim maintenance. And considering the fact that his take-home salary is 31,218 and the net salary is 43,164, court had granted an amount of rupees 20,000. Agreed thereby the husband is before this court. On 3/7/2024, this court passed the following order, extract the order. And on the last occasion, this court has directed the husband to file the latest salary slip. By way of a memo, the latest salary slip is placed before the court. And as per the same, his gross pay is 60,350 and his net pay is 52,112. Which, looking at the salary, the income of the petitioner husband, the trial court had rightly granted 20,000 as maintenance, and this court finds no reasons to interfere. Dismissed.
Arrears of maintenance.
You have your own courts that in his petition, court will not tell all that. Yes, next.
Cell number 3. For return.
Do that.
For the appellant in this matter, my lord.
Memo of retirement.
Filed a memo seeking that I be permitted to retire from the.
Yes, filed the memo for retirement. Where is it? When was it served on him?
My lord, online shows that insufficient address, my lord.
Then
This is the address that is there in the cost title also, my lord. I checked this online. It shows that it's insufficient address.
we will not permit you without that being served on you.
My
Post
lord,
this
I
matter.
don't have any, I only have the address that's
Post
mentioned in
this
the cost
matter
title.
After vacation. Yes. Next.
4. Shetty Deepak.
Serial number 4, my lord.
Yes.
Respondent number 9 to 15 are, my lord. The sailing with the appellant, my lord. The notice may be kindly be dispensed with because they are.
File a memo.
I'll file a memo.
File a memo, then only it will be
So
dispensed with.
I'll file my memo.
No, please file a memo, then call the case.
Please.
Yes.
Sale number 5.
My lords, appearing for the appellant.
Onion KBS.
Yes.
My lords, in there are 3 connected appeals. In the first appeal, a translated copy of the interim order has already been furnished to the court. In the second appeal, my lord, since it derives out of the same interim order, I agree. It would file a dispensation application because the certified copies are attached in the first appeal.
Then you file the typed copies in this.
Yes, your lord, true copies have already been attached
Mm.
in the second appeal.
Mm.
My lord, the third appeal is again an incidental relief that was sought in terms of the first appeal. So regarding that.
No, look at the cost title. Office objection is kept open with regard to challenging IA number as per court order dated 11/6/2024. What is that?
My lords, if you have a look at the appeal,
MFA is filed against which order? First one, 2637.
2637 is on IA number 2,
Hmm.
my lords. And it is a common judgment on IA number 2 and IA number 5. So we filed 2 appeals for IA number 2, one for IA number 2, another appeal for IA number 5, another appeal for IA number 4, which was incidentally dismissed, my lord. My lord, this matter has already come up in the admission stage.
11/6 order is office objection is kept open. What is the office objection? Only these are the office objections.
Yes, my lord.
The transfer appellant has challenged in I number 4.
Since there is no court order on IA number 4, that is why the office has raised an objection. But the IA number 4, the relief sought in IA number 4 is incidental to IA number 2 and IA number 5. My lord, if you kindly look at the appeal, I'll just read out the relief.
No, let's look at the interim order, impugned order. Page number.
'24, my lords.
I'm looking at MFA number 2637.
2637. Yes, it's
a common order.
It's a common.
Yes, which
Please.
page?
Page number 23, my lords.
It's in Kannada.
My lord, translated copy has also been filed. So, my lord, if you have a look at the
Order on interim application numbers 2 and 5.
So the relief that was sought in IA number 2, my lords, was for restraining the defendants from carrying any construction activity and changing the nature of the suit. This was the relief sought in IA number 2. The relief sought in IA number 5, my lord.
But IA number 5, when it came to be heard by the court, it was not heard. This application is only IA number 2 and 5.
Yes, my lord.
4.
4, since the relief is incidental, my lord. If you have a look at this thing.
There is no, for that there should be a consideration by the court.
My lord, since it is an incidental relief arising out of the same suit, is why we had to file.
There
My
should
lord-
be an order. There should be an order by the court.
Yes, my lord, it's an incidental relief. That's why.
My lord, if you have a look at the prayers in the
Yes.
interim order, my lord, I'm looking at appeal number 2636 of 2024 at
Yes.
page number 52.
Hmm.
We've asked for in relief of temporary injunction, directing defendants to demolish the structure.
Which case?
2636
Hmm.
at page 52.
Hmm.
Directing the defendants to demolish or put down the construction put up by the defendants in haste over the Schedule B property, despite the objections of the plaintiff and notice of the honorable
So,
court.
there should be consideration, there should be an order. Without an order, you cannot say that I can, okay, again, it's what an appeal and a miscellaneous appeal can be preferred.
My lord, one small submission. My lord, this relief, the interim order on IA number 2 and IA number 5 is regarding temporary injunction. And
That you can't file an appeal like that without an order saying that it is
my
incidentally.
lord, IA number 4 was dismissed incidentally by the trial court.
It was never felt for consideration before the court in the impugned order. It only speaks about IA number 5 and IA the other IA. If you look, please look at the order. From the order I am saying. If you understand something the more than what the court says, then on that an appeal can't be filed. Order on interim application number 2 and 5.
2 and 5.
That's it.
Yes, my lord. Okay.
What is it? So this office objection with regard to MFA number
2636 on IA number 4.
8 of 2024 is sustained.
My lord, 2638, no, 2636.
2636
is on IA number 4.
The
2636.
office objections with regard to in respect of MFA number 2636 of 2024 is sustained. Yes.
Yes, my lord. My lord, can we have it on the admission stage, my lord? The appeal.
Post is in MFA number 2637. The translated copy of the memo is filed. Post MFA 2637 and MFA 2638 of 2024 for admission.
Good.
Chair number 6. J. Krishna Bhatt, paper 1 week time.
Week's time.
Much obliged.
Default order.
Chair number 7. Ashish Krupakar.
If your lordships recollect.
My lord, I represent the petitioner, my lord. This writ petition has become infructuous.
Yes.
This was against the order dated, my lord, 24/9/21. There was an interim order of this honorable court, my lord, staying the order and permitting the respondent to celebrate the birthday of the minor child, my lord, for a few hours between 2:30 to 7:30 on 29/9. Now the said order is, my lord, rendered, this writ petition has rendered itself infructuous, my lord.
That's another petition, they had withdrawn in the chambers, if your lordships recollect.
That has no connection, my lord, to the facts of this case.
No, what is this order? No, let's understand from this order. What
My
is
lord,
the
may I request your honor to turn to page 38, please, my lord.
38.
38, please. My lord, this was an order on passed on IA number 13, where the Honorable Family Court, my lord, I may be permitted to take my lords to directly the operative part, which my lord will find at page number 40. IA number 13 filed under section 26. My lord finds it. IA number 13 filed under section 26 of HM Act, read with 151. Respondent is permitted to take the child from the residence of the petitioner to his custody at 6 p.m. on 28/9 and shall make arrangements to the child on 29/9 to attend online classes and also celebrate the birthday of the child, and shall hand over the child to the petitioner at 6 p.m. on 29/9 at her residence. Petitioner shall hand over the child to the respondent as per the order as aforesaid, and the petitioner is also entitled to join the respondent to celebrate the birthday of the child if she wishes to join. Against this order, my lord, approached this honorable court. This honorable court on 24/9 was pleased to pass this order, my lord. Office objections are overruled. Issue emergent notice, interim order is prayed for. The fair submission of the learned counsel for the petitioner that the respondent husband may take the child for a few hours for the celebration of its birthday, the ideal time being 2:30 to 7:30 with some flexibilities, and that she will cooperate in that is placed on record. My lord, based on this order for the last 2 years, my lord, the parties are celebrating the birthday of the child, which is on 29/9. Now, my lord, this order has rendered itself infructuous.
He wants to withdraw, then I'm okay, because the connected
No.
matter also he has withdrawn, because I filed an application.
My lord, it may be dismissed, it may be closed as.
Let her submit, you are submitted, let her submit.
I filed an application before the family court to consider my application for overnight as granted earlier for the birthday.
Let the court consider.
Because of the interim order, the court is not taking that.
The agreed with the orders passed in I number 13 in MC number 3648 of 2018. The mother is before this court. I number 13 is filed by the father. And in that, the court had passed an order permitting the father to take the child from the residence of the mother to his custody at 6 p.m. on 28/9/2021 and shall make arrangements to the child on 29/9/2021 to attend online classes and also celebrate birthday of the child and shall hand over the child to the petitioner to the mother at 6 p.m. on 29/9/2021 at her residence. It is also observed that the father shall hand over the child to the mother as per the order and is also entitled to join the wife celebrating the birthday of the child. If she was, the mother can also join the birthday celebration of the child if she wishes to join. Against that order, the present writ petition is filed. This court on 24/9/2021 interim order was granted, and the court observes that the fair submission of the counsel for the petitioner that the respondent husband may take the child for a few hours for the celebration of its birthday, the ideal time being from 2:30 p.m. to 7:30 p.m. with some flexibilities, and that she will cooperate in that is based on record. Land counsel appearing for the mother submits that from the last 2 years, the father was celebrating the birthday of the child. And now literally this writ petition has become infructuous and no further orders requires to be passed in this writ petition. Accordingly, the writ petition is dismissed as infructuous.
Grateful, my lord.
Let the trial court not be influenced.
No. I'm sorry, my lord. That's on a different footing.
Trial court not be influenced by this withdrawal because I filed an application.
I am not withdrawing. It has become infructuous.
There's no question of influence because court has not expressed anything on the merits of it.
Yeah, the question that does not arise.
To that extent also would be, the court is not expressing anything also would be, because then.
No, I am sorry, my lord.
That's his writ petition. He wants to withdraw.
Because the connected also is withdrawn and he is exercising.
Let him withdraw.
Great, no?
Yes, next. Respondent is here. Right, Pratima appearing for the respondents. Yes.
My wakalat is there.
I think it's not reflecting, that's what she's saying.
Cell number 8, Hari Kumar C.
For the respondent in this case, only a 2 week short accommodation. He lives in.
Non-filing of wakalat. Why you are not filing wakalat?
Lord, he's staying in Australia, my lord. They have sent my lord. I have 100.
No representation for the petitioner at the request of land counsel, the respondent. For this matter on 30th of October. This next.
Yes, my lord.
Cell number 9.
For the petitioner. For the respondent. I'm filing the assets and liabilities. I've served the copies on the other side as well. My lord, 5.5 lakhs is the reasonable claim maintenance per month. It may be looked into, my lord. That would I will go through that. That would be addressed now. I'll go through, my lord, the visitation, my lord. I've been having
going on
4 hours from 1st of from 31st of July, Your Lordship passed the order. 4 hours, my lord, myself and my parents are going and visiting the children at the clubhouse of the apartment where the respondent resides. But that's been going on now for almost 2 months. But kindly permit me to, my lord, pick up the children and take them because they're not small children. But boy is almost 11 years old and daughter is 6 years old.
We'll do one thing. This Saturday, we'll permit him to take the children out and we'll post this matter on Monday.
My lord, with respect to the same,
We'll post this matter on Monday.
My lord,
That day you can
it's-
submit what has happened.
my lord, it's a sincere request as such. I had also submitted prior that the minor son, who's of 11 years of age, has expressed certain concerns and that should be addressed. Why?
Okay.
Because what's going to happen is that now the petitioner, the father himself has idea of the same and he's been discussing the cases with the child and the child has been coming back home and has been questioning the mother. That is what's happening on a day-to-day routine, my lord.
We'll tell
Lord,
him
so with
Lordship-
respect to the same, even keeping all of this
to
aside,
do it.
my lord, keeping all of this aside, I've received instructions from a client that she has a proposal, keeping in mind the interests of the petitioner, which should, if addressed properly, to amicably settle the whole matter. So all I request is that the matter.
She will not allow them to.
No, nothing like that, my
Then-
lord. All the request is the matter may be taken up on Friday. So tomorrow I can have a discussion with the learned counsel.
We'll
And,
have it on Monday. Court is not sitting on Friday.
my lord, then at least this weekend, let it continue 3 to 7, him coming to the clubhouse because she is looking into a particular arrangement wherein the father would have more
Please understand, for this Saturday and Sunday, we'll make an arrangement. How it works out, we'll see. Basing on that, if it is not working, it's not, as you said, that the children are not happy or whatever the reason, whichever you want to say, you can submit it on Monday. On Monday, because vacation is intervening, so we have to make some arrangement in between also.
Definitely, my lord.
For this weekend, at least on one day, I think he's having both Saturday and Sunday.
Both Saturday and Sunday.
Saturday and Sunday, let him have on either Saturday or Sunday in the same, like how the earlier arrangement is made. One day, let him take the children
My
outside.
lord,
We'll
the
see.
apprehension is that he would affect the child's mental health negatively, my lord, because
Monday.
yes, my lord, the minor,
Then we will pass orders. On
My lord.
Monday, no, if that's the case, if really something like that happens.
I will file an
Will not grant anything, will not grant the visitation on, from.
No, my lord. So
10th.
keeping all the factors in mind, all that I'm asking is that the matter be taken up on Friday. I believe that the client, the respondent herein is willing to be more than fair. She wants the petitioner to also take up responsibilities as a father. So she's trying to come up with a certain arrangement, the intricate details of which have to be worked out. That is all. It will definitely
I
put
think he's paying 2.5 lakhs or 3 lakhs towards the fees.
my lord, in that, not towards the fees, my lord. It is 1,35,000 that has been paid after the residence orders passed. The residence order was passed in the month of April, my lord. Till then, for almost 18 months or more, she was left out on the streets, my lord. She had to survive based on her father's mercy. We have the orders. The petitioner here, it was also addressed.
Agree.
No, I beg the
as
submission.
per
No,
order
I want-
passed
The
for this-
petitioner,
I have one
my lord,
submission.
just one submission. my
Sorry,
lord.
sir, 1 second. My lord, my learned friend is making a submission before your lordship. A responsible counsel is making a submission that the father is discussing the cases with the child. Lord, I will place on record what happened before, last week. My son is in the hospital for 4 days. I am not informed. I see an email from the insurance company saying the insurance claim is rejected. When I call the insurance company, they inform me that my son is in Manipal hospital. I write to the respondent does not respond to my email. I end up in the hospital. My lord, who opens the door at 9 o'clock in the night? The counsel opens the door in the hospital. And the counsel is making a submission before the. Kindly wait one second.
Sir,
Counsel is making a submission. Kindly wait. When the counsel is making a submission, I'm talking about cases. A counsel is representing my wife in the cases before in the hospital, interacting with my son. I did not want to bring places on record.
Your Honor, it may be placed on record. Whatever they insinuating it.
I will file an affidavit before the court.
It may be taken on record. Let then affidavit be filed. There is no restriction per se. The reason being, I had to file the assets and liabilities, my lord. It was a strict instruction of the court that I have to file the assets and liabilities. You may check the documents, my lord. There's almost 200 pages, my lord. How is she supposed to take care, obtain the documents? I had to work it out with her. So we are not going into the personal aspects. So there is nothing barring me from. Yes, she herself was sick, my lord. I had made a submission that she herself had been sick. She had influenza. The kids had influenza. The son had to be admitted. So she's never, there's no, the allegation raised here doesn't have anything to do with the custody or the maintenance aspect.
The counsel being in the hospital.
What wrong does it do?
Does not expose my son to court cases or court proceedings. But me meeting my son Expose
My
them to court
lord, my lord,
proceedings.
considering the claims, let the honorable court interact with the child. It will put all these allegations to rest. This is what we've been asking from the very beginning, my lord, that the child should be interacted with.
Order passed by this court, the respondent mother had placed before this court the statement of assets and liabilities, which will considered by this court on the next date of hearing. Learned counsel for the petitioner father submits that the father has been visiting exercising the visitation from the last 2 months in the clubhouse of the apartment.
And the grandparents.
Huh?
And the grandparents.
More than the grandparents at the clubhouse of the apartment where the mother is residing. He submits that the father may be permitted to take the children outside the premises and exercise the visitation. The father, as per the earlier order, is exercising the visitation on a Saturday and Sunday. On this Saturday, at what was the time?
It was 3 to 7. I stay in Hebbal, they stay in Whitefield, not 10 to 5. On one day, I will not press for 2. On one day, not 10 to 5, I will take them. Because, but the time I come,
Sunday, there is no visitation there.
no, your lordships, I have granted visitation both Saturday and Sunday.
That's why you are having it from 10 to 5. You will not have it on Sunday.
Or it may be given on Sunday, but not Saturday, let the children be with the mother.
On Sunday or Sunday, the father can take the children at 10 o'clock and drop them back at 5 o'clock. Post this matter on Monday, basing on how the visitation goes on and the further orders will be passed. The father is directed not to keep the children comfortable and he shall not discuss with them about any of the cases, or he shall not talk to the children against anything against the mother.
My lord, also recordings of the kids, my lord. Recording the kids. So the kids have told that the elder son has said that he might be recording because the father's got a phone around. It may be put on record that he might not record because there's precedent as well, wherein during one of the state visitations as such, wherein the father had to meet the child in the park. Instead of spending time with the child.
Because, please understand, please understand from the side of the father also. Now, you will come to the court and say that the boy is very uncomfortable.
My lord, the recording.
So to prove
My
the
lord,
court,
my lord, if it was recording.
they shouldn't be involving in all this.
My lords, the court's mic has been muted, my lord.
Rupesh B.
My lord, in this case, for the respondent, I have received the wakalat only yesterday, my lord. I may be given a day's time to file wakalat for the respondents.
You have an interim order in this?
Nonetheless.
Any interim order in this? No?
Petition by
Learned
wife of
counsel.
wife.
What is your name?
B.K. Mohan, my lords.
Learned counsel, Mr. B.K. Mohan submits that his instructions to file wakalat on behalf of respondents. You can go after vacation. Pose this matter
Any date?
on 21st of October.
Grateful, my lords.
Yes.
Copy served. minutes.
Yes, I have received the copies. I have received it.
It is submitted that the council has already served the copy on the council for the respondent. Yes.
I have received, my lords.
Call the pass.
First over matter, serial number 7, list 1, serial number 7. Speak on.
About my lords, issuance of succession certificate, my lords, in respect of immoral properties. And I brought your lordship's notice, my lords, another order. My lords, it may be permitted, my lords, make few submissions, my lords, on section 370, my lord, that is
Yes,
what is concerned.
Take that, provision. Succession Act. Yes.
Because, my lord, the learned single judge, my lord, so this honorable court says, as per section 370, it is not, it cannot be issued. But the heading itself, my lord, of the provision says, my lord, restriction on grant of certificates. It's only,
It's
my
what
lord,
it is like,
exception drawn, my lords, to a general rule. And, my lord, the subsection 1 also, my lord, succession certificate hereinafter referred to as so-and-so shall not be granted under this part with respect to any debt or security. That is also not what I'm submitting is only an exception. And my lords, reference is also made, my lords, to section 212 and 213 of the Act, where it says, my lords, in respect of debt or security to which a right is required by section 212 or section 213, or my lord, is to be established. My lords, in fact, my lord, section 213 also, in fact, refers to immovable property, my lords. That means to say,
yes,
there cannot be any generalized view which can be taken, say that it is not applicable. And, my lords, the section 210 also, my lords, for a moment. Two 211, my lords.
1 minute.
211. Says, my lord, the executor or administrator, as the case may be, of a deceased person and his legal representative for all purpose, and all property, my lords, is the word used. There's no distinction about movable or immovable. All properties, my lords, is the word used.
What is the other provision you're referring to? 370?
My lord, section 370, my lords, is the provision.
That I've seen.
372, my lords, are for application. My lords, particularly section 372 1D, my lords. It only speaks of, my lords, the right in which the petitioner claims. There is, my lords, a clear distinction, my lords, to 31F, where, my lord, separately the debts and securities, my lords, are mentioned. That means to say, my lord, as per my understanding, there was no necessity to say, my lord, state, my lord, separately about the right, and, my lord, the debts and securities, my lords, in the provision.
No, the court had dismissed on what ground?
My lord, saying that it is not, it cannot be
Relying on
issued in
this
respect of
judgment?
immovable properties.
Relying on this?
Not this, my lord. This judgment came, my lord, subsequent to, my lords, the.
Then
My lord,
let's look at the reasoning.
please.
What is your application?
My lords, for grant of, my lords, our understanding was, my lords, we are only the surviving heirs, and it should be issued in our favor. My lords, there was no objection also from, my lords, any person. Your lords may kindly have, my lords, page number 25, para 10, my lords, is.
You're asking in respect of your uncle's property.
Yes, madam. We are the only heirs, and, my lords, we are granted certificate by in other proceedings, except this property. That also, my lords, we produced.
Heard, reserved.
Published.
Next.
Cell number 9. Cell number 9.
Madam, for the petitioner. My lord, it is that matter, my lord, where my lord had referred the child, my lord, to be taken to Niemann's for mental evaluation. Now, my lord, kindly sees your lordship's order dated 30th of August.
Yes, what is happening?
We have not gone for the admission at enhancement.
Why?
My lord, the child is showing
Huh?
resistant towards admission, my lord.
What is that?
Child is showing resistant towards admission, my lord. She's not willing.
I didn't get you.
The child is showing resistance, my lord, for admission.
So what are you supposed to do then? Have you brought it to the notice of the court?
My lord.
Why?
There was a order not to move the matter from.
Does it mean that not to move means that you will not, you will not honor the order of the court and you will, whatever you want to do, you will do?
No, my lord, that's not our intention, my lord. My lord, also, there are certain concerns with the admission as well, my lord.
Yes.
The Mental Health Act, my lord. A copy of that.
No, that is not, this is not the stage for all that. This is not your application at all. You cannot come up with all this now. What is to be done now? Shall the court pass an order? Or we take contempt proceedings to be initiated against the mother?
No.
That's the only option left.
My lord, private counseling institution is.
It's not whatever she wants to do.
My lord, it's not even about the mother, my lord. The child is showing extreme resistance, my lord. She is really unwilling to go to that place, my lord. It
She's
is
unwilling
really-
to do so many things. That's the reason why the court has to send her. You are not, what the court can understand is, you don't want her to be normal. If she is in the same set of mind, I think that suits the mother. That's what appears to be.
My lord, here, my lord, indeed, my lord, we completely agree with counseling that is required for the minor child, my lord. We're not even against it, my
You
lord.
have seen the doctor, what did they say? Even to assess what's a state of mind, it cannot be assessed on a 10 to 4 o'clock or on a kind of sessions.
My
To
lord,
understand, in the earlier order also, the court has passed the same order. In fact, the court has spoke with the director of NIMHANS. He said the manner in which the girl is behaving with her set of mind, it is not possible. Why is the mother not understanding it?
My lord, here, my lord, when it comes to admission, the Mental Health Act speaks about the admission where they have to do 7 days of continuous counseling. And admission is only done when there is an extreme mental health condition that is there.
What do you think that she is normal with what she is speaking?
Indeed, my lord, she needs counseling, my lord. Direct.
You are not the
going-
doctor, I think,
Indeed
for that matter. It's for the doctors to say. You cannot submit. This is not a legal issue where you will submit that this is not the provision, something else. You are not competent to speak on that. That is a doctor who has spoke. There is a report before the court saying that it has to be done in that manner. Now, by the Google knowledge, one cannot tell the court that how it should be done. It's a doctor's analysis and his treatment. That's how it has to go. The
Indeed.
mother has no business to say anything in this.
My lord, it is not, this is from the Act, Mental Health Act perspective that I was speaking, my lord. My lord, that part when she was admitted there, she was attacked by.
And you take her every day 20 kilometers up and down, and you take her to school.
My lord,
And you tell the court that no, the court has to give a finding on this, saying that the mother is not interested. Whatever the mother's behavior is not in the interest of the minor. And the minor who makes those kind of allegations against the father, when all of you are present, and you still feel that the girl is normal, and generally these kind of treatment is in extraordinary or circumstances. Don't you feel that the manner in which the girl was, talking about all the things which has never happened, is it a normal health condition?
my lord, but my lord, the counseling, everything is very much. in
It's not about
best
the
interest.
counseling. It is about the assessment first.
Assessment.
First, you have to understand what is the problem. Once you understand the problem, then the question of counseling will come later.
Indeed, my lord, she is put.
For that, they need to look at her right from the morning to evening. And to assess her, it's very difficult.
Definitely, my lord. My lord, here what is happening?
Let the mother come before the court. I think she requires, then before her, I'll pass an order. Tell her that I'll definitely take it as a contempt. Will suo motu initiate contempt proceedings against the mother. Tell her to come on Monday. Yes, pose this matter on Monday.
Good.
In spite of an order by this court, on several occasions, on one reason or the other, the mother has not joined the child in enhance. When the enhance doctors have given a report before the court stating that she has to be admitted, considering the disputes between the parents and the manner and assessing the girl as a outpatient is not possible. In those circumstances, an order is passed. The mother, on one pretext or the other, is not complying with the order of the court. And when the father has moved an application, then her counsel submits before the court that the girl is reluctant. It was never brought to the notice of the court, and it appears that there is no intention on the part of the mother towards the welfare of the child, and and she is now coming up before the court saying that it can be as per the Mental Health Act, it has to be other way. It is not, the admission is not required. And now the mother is trying to tell the court, is submitting before the court as a doctor what has to be done, which cannot be appreciated. This is a clear case where the suo motu contempt proceedings have to be initiated against the mother. Pose this matter on Monday. On Monday, appropriate orders will be passed.
Great.
Seal number 25. Amit, yeah.
Respondent.
CH Jairaj.
Appellant in this matter.
So who are the respondents in this?
It's respondent numbers 1, 2, and respondent numbers 4 to 7, I represent them.
No, respondent number?
Respondent numbers 1 and 2.
1 and 2?
Respondent numbers 4 to 7.
4 to 7 you represent. Then about 3, 8 and 9?
No, now, my lord.
Huh?
Now, the interim order before the trial court, my lord, has been rejected. We will seek interim order only against the proposed respondent, my lord, who has purchased this property after impleading.
So no adverse orders to any of the parties.
Please, my lord.
The present MFA is filed. Agreed with orders passed in I number 11. Dated
Dated 7th June 2024.
I number 11 and OS number 356 of 2014, dated 7th June 2024, whereby the court had dismissed the IA filed by the plaintiff. The suit is filed for?
Partition. my lord.
Suit is
Partition.
filed for partition. As which defendant has alienated?
My lord, first defendants 1 and 2, my lord.
Defendants number 1 and 2 had alienated the suit schedule property. Hence, they have filed the IA, seeking a direction not to put up construction
No,
of
no,
the,
not to alter in any manner, nature of the property. Not to alter.
changing the nature of the property and putting up construction over the suit schedule property. In that, the plaintiff had not impleted the purchaser to whom the property, has not impleted the purchaser. On that ground,
Para 13, my lord, para 13 of the order.
on that ground,
Page 25, para 13, my lord. Para 13 and without impleting the purchaser,
you're reading para number 13.
please.
Para number 13, it's not there.
It is at the end of that para, my lord, para 13.
Oh. What is the internal page of the judgment? That order?
10, my lord, 10,
10.
please.
Temporary injunction to entertain so and so with respect to property, that the injunction is sought without impeding the purchasers who are the proper and necessary parties to this suit and the IA. And accordingly, the court had dismissed the IA filed by the plaintiff. Agree thereby, the present appeal is filed. When the, now, and this, the respondents respondent 1, 2, and 4 to 7 are represented by an advocate. Respondent number 3, 8, and 9. Notice is not ordered no notice is not ordered. Land counsel appearing for the appellant submits that they will file an appropriate application by impeding the purchaser. And hence a liberty may be granted.
My lord, I am told application is filed, but not yet served.
That they'll proceed further. It is submitted that they've already filed an application by impeding the purchaser, and they may be given liberty to pursue the said application. Though notice is not served on the respondent so and so, but still this court is passing an order for giving liberty to the petitioner, to the appellant plaintiff to pursue the said IA, as no adverse orders are passed against that. Accordingly, the MFA is disposed of, giving liberty to the appellant plaintiff to impede the purchaser and file an appropriate application.
The trial court may be directed to dispose of such application, my lord, without being influenced by the earlier order. My lord.
The trial court shall independently deal with the said application without being influenced by any of the observations and the findings of the earlier order.
Much.
That I said so.
Much obliged.
Yes.
Cell number 26, Vikram Munni, Rajgopal.
Lord, defendant's appeal challenging the order of the trial court granting an order of temporary injunction restraining me from alienating or creating any third-party rights over the suit scheduled property. I am the absolute owner of the suit scheduled property, my lord.
What is the suit?
My lord?
What
Suit
is
for
the suit?
declaration, my lord. Declaration that the sale deed in my favor is null and void.
Date of your sale deed?
Date of the sale deed is 2012, my lord, which is at Annexure D, 10/12/2012.
This injunction is restraining you from interfering.
Restraining me from alienating or creating the third part rights.
And what about he sought recovery of possession also?
He sought recovery of possession also. I've been in possession since 2012. My lord, the scheduled property originally belonged to my father, one Ramachandra Upadhyaya. He passed away in the year 2007. Subsequent to his death, family members entered into a partition deed.
No, instead of passing so many orders, let them come, we'll dispose of the main.
Lord, I'm seeking for a stay of the proceedings. The party is coming up on 27th for plaintiff evidence, my lord. The suit is ex facie barred by limitation. Court fees is not paid. I kindly see the receipt.
It will be decided now. You're on an IA not to alienate.
Yes, my lord.
No, nothing will happen in 15 days when once the other side comes. And question of staying further proceedings will not arise in this. The petition, the appellant is permitted to take out notice on the counsel appearing for the respondent before trial court. It shall file a memo to that effect. If the memo is filed on by 14, list this matter on 16.
Grateful, Lord.
Cell number 27,
For appellants in this matter, my lord, so suit for a comprehensive suit for declaration possession. That's my only prayer before this honorable court is the respondent is trying to create third-party rights. The facts of the case are, my lords, in the year 1948, my father succeeded the property of survey
So
number.
you're seeking declaration and recovery of possession.
Yes, my lords.
And what is the sale deed in favor of the defendant? Which year is that?
My lords, the facts are different, my lords, likely different. The thing is, my lords, after the purchase of the property, defendant number 1 has purchased the property from my father. After purchasing it, there was 79 A and B proceedings initiated in the year 1996 itself. Subsequently, after this, the defendant number 3 has purchased the property from defendant number 1, which already seized by the government. After purchasing 6,000 square feet, now the remaining portion which I was left over, that is 4 acres, in that he has been encroached. Initially, I filed a suit for injunction. Injunction was granted in my favor. Subsequently, when it was vacated, again he has encroached and has made a construction. Subsequently, I withdraw the original injunction suit and I filed a comprehensive suit now. So initially, the second suit also, the interim order was given by the Honorable Court. And subsequently, it has been vacated. My only apprehension is third-party rights should not be created. That's my only request, my lord.
How your application is dealt with by the trial court? Let's see that.
Yes, my lords. And there is no proper findings given by the trial court, my lords. Madam, the reasonings will start from page number 65. Or may I just read the entire order, my lord?
Reasoning.
Yes, my lords. Page number 65, para 8. In order to avoid the petition.
The wrong file.
66, my lords. I have perused the materials placed by the parties to the suit. 66 page number. Internal page 11 of the order.
66
Yes, ma'am.
is affidavit.
My lords, the impugned order starts from page number 82.
Impugned order starts at page number 15. 14 it starts. 24th April 2024 order.
Yes, my lords.
It starts at page 14.
My apology, my lords. The
Yes.
page name is different.
Yes.
In that, my lords, internal page or order, page number 11. I have perused the materials placed by the parties to the suit. The plaintiff has filed the suit for declaration and injunction and for recovery of the position with respect to the suitable property. It is his contention that the plaintiff that the land measuring 3 acres of the land out of survey number 62/3 was sold by my father of plaintiff and plaintiff on 21/4/1986, and another extent of 3 acres of land was sold in favor of one Gulzar on 1/12/1986. Subsequently, 18 guntas of land in survey number 62/3 was acquired by the government for expansion of the road leading to Parapna Agrahara. The plaintiff and his father retained 4 acres, 5 guntas land out of 10 acres, 23 guntas of land, and the suitable property is the land measuring 6.5 guntas out of 4 acres, 5 guntas of land retained by the plaintiff. It is stated that the 3 acres of the land sold in favor of the defendant number 1 was acquired by the government by virtue of the proceedings under section 79A and B of Karnataka Land Reforms Act, order dated 22/9/1986, and the government has taken the position of the same. Thereafter, the defendant number 1 has sought to sell an extent of 6,540 square feet of land in 3 acres of land in favor of the defendant number 2 white sale deed dated 30/5/2013. And on the basis of the sale deed, the defendants are trying to interfere with the plaintiff's peaceful possession and enjoyment over the suitable property. And in this behalf, IA is filed requesting the court to pass an order of temporary injunction restraining the defendant number 2 from alienating the suitable property. Admittedly, the suitable property and the written statement scheduled property are entirely different. The written statement scheduled property is the schedule of the sale deed dated 30/5/2013. It is not demonstrated as to how the plaintiff has apprehended that the defendants may alienate the suitable property without any title deeds in their favor, and the relief sought by the plaintiff is not with regard to the restoration of possession, but with regard to the rights of the plaintiff number 2 to alienate the
So the
property.
court on the point that the written statement scheduled property and the plain property are not one and the
It is
same.
one and the same. My lords, I will demonstrate. My lords, the plaintiff which he is claiming which he has retained the property is 4 acres, 5 guntas. Wherein the defendant herein, the third defendant which he has purchased out of the 3 acres which was acquired by the government. Government 79A and B, the proceedings were initiated. So that order has become finality. 1996. Till today, they have not challenged it, even though the order has been repealed. Now, he is claiming the title from defendant number 1. Nor his case is that he has purchased it from my father or I have sold it. It is not his case.
Your father has sold to D1.
My father has sold it to D1.
From D1 in turn, he has purchased it.
True, my lords, when he cannot purchase it because the property is already vested with government. How can he purchase it? That is the question, my lords, that the trial court did not understand it properly. He is not claiming through my father, or his case is not that I have sold the property to him. His case is he has purchased it from D1. He has purchased it from D1 recently, my lords. This has happened 1996, the 79 AB proceedings are being initiated. When the matters are seized
What you are
before the.
saying is that the property which already vests with the government.
Yes, my lords, that
has
is being purchased by defendant number 3.
Hmm.
How can he purchase, my lords? Prima facie.
He purchased.
He purchased, he has
That is
purchased.
re- he has
I am not
purchased
disputing
it.
that, my lords. I am no way concerned.
That property.
Yes, my lords.
Which is already acquired by the government.
Yes,
If he is trying to sell it, how is that it is going, what is the,
My lords, that is not the question here, my lords. Now he has encroached 6,500 square feet of my 4 acres, which was left over by my father. That is the question, my
so
lords.
first that has to be decided, which is the property encroached by him.
Only
As far as a.
through a
written
trial, my
statement
lords.
property
Only
is
through the
concerned-
trial it has to happen, my lords.
Yes.
For
For that,
only,
how can they, no, as far as the written statement scheduled property is concerned, you have nothing to do. You are only talking about some encroachment.
only
For
an encroachment.
No, for that encroachment, how
Yes,
can
ma'am.
there be an order that the entire property should not be?
I
alienated?
never questioned about the entire property, my lords.
But
I am
you're
only
saying it's
questioning.
not to alienate the
Not
entire
to alienate with
property.
respect to that 6,450 square feet is my question, my lords. That's the only prayer before this honorable court, my lords. My lords, suppose, my lords, I have some documents to show that he has forged documents and obtained the orders, my lords. I am producing 2, and he is claiming that he has purchased, he has taken the sanction plan.
It has to be heard. It has to be heard along that
My lords, I am
respondent
not
represent-
requesting for the stay of the further proceedings, my lords, because I'll be affected.
Even this also, not to alienate also, the court has to be satisfied on that.
Until
are
next
saying-
date of, until they come and make their submissions, my lords.
Let
It
them-
has to be protected. The only reason is, my lords, now all along, if at all he alienates, again I have to implead them.
Is this order passed?
Recently,
24th
my
of
lords,
April,
very recently.
2024.
Very recently.
That at the end of 15 days, it can wait. The
Next.
appellant is permitted to take out notice on the counsel appearing for the respondent, shall file a memo to that effect by 14th of October. If it is filed, post this matter on 21st of October.
May one indulgence, my lords. Until they come and appear, my lords, let there be some status quo, my lord.
No, for that,
No,
the
status quo, my lord. I'm not asking that.
Status quo is an order, it's a double-edged sword.
Fine, my lords.
Can't be
At least third-party rights may not be created, my lords. Only that.
But that also I'm not convinced. Yes, next.
Cell number 28,
Obliged.
J. Kumar K. For appellant,
In this matter appearing for the appellant, my lord. This is the plaintiff's appeal, my lord. Plaintiff filed a suit for injunction, my lord. Again, it's the defendant. Trial court has come to the conclusion that, my lord, a plaintiff has made out a prima facie case and grant an order of only in part allowing, but direct the parties to maintain status quo. My lord, my application, my lord, page number. Suit for permanent injunction, restrain the defendant from interfering with the plaintiff possession.
No,
My lord,
the court
plaintiff-
says status quo.
My lord,
Oh, the court says
yes,
status
allowed
quo.
the
What is the
IA.
ca- What is the case of the plaintiff?
Plaintiff purchased property under the sale deed of 24/3/2016. The sale deed was executed by the court, my lord, under the specific performance suit, my lord. An agreement was executed and I am nominated as a nominee on behalf of the decree holder, and I entered into, and the court has executed the sale deed, and I am in possession of the property. Now the defendant's claim, my lord, is in respect of some other altogether property, and they are nowhere concerned with regard to the scheduled property, since in the defendant written statement clearly admitted that they have a site number 1 and 2. This site is totally different. My lord, may I kindly look at page number 18 of the impugned order. The trial court findings, my lord, is that whether the plaintiff has made out a prima facie case, court answered.
What is the case of the defendant?
My lord, defendant case, my lord, is that they are purchased site number 1 and 2.
Yours is?
My site number, my lord, is site number 20. 20 and site number 1 and 2.
So even though these numbers can't be adjacent to the other.
Not, because your lordship may kindly see the page number 29, the plain schedule.
Please come to the order.
Order, my lord. Page 18, my lord, findings, my lord. All for 3 points, my lord, court answered is affirmative, affirmative, affirmative. Balance of convenience, yes. Balance and irreparable loss will be caused to yes. The reasoning, my lord, is come to the page number 8, para number 8, my lord, page number 18, point number 1. As per the case of the originally the scheduled property belonging to one Muniappa, during the lifetime of he was in possession and enjoyment of the same. After his demise, revenue records mutated in the name of his wife Mangamma, and subsequently she has gifted in favor of her son Lokesh through a registered sale deed and registered gift deed dated 1/2/2012. It is also said that said Lokesh executed an agreement in respect of scheduled property in favor of one Ganesh and Karthik. It is also stated Lokesh has failed to execute the sale deed. Therefore, Ganesh and Karthik have instituted a suit in OS number so and so before the City Civil Court, Bangalore, for the specific performance of sale agreement, which came to be compromised and decree. And in the meantime, Ganesh and Karthik have assigned the decree in favor of the plaintiff, and therefore plaintiff has assignee of the decree filed in execution number so and so and obtained a sale deed on 24/3/2016. Though the process of the court and thereby he has acquired the title and possession over the property, the objection raised by the defendant is that gift deed and execution of proceedings are collusive in the guise of the decree, and sale deed of the plaintiff is claiming right over the property of defendants. Your Lordship, kindly look at the written statement. Their written statement, the property of the defendants. Page number 38 of the written statement I have produced their contention and their statement.
Please read para number 10 of the order.
The defendants have produced several documents to establish their claim in respect of their two sides. Though the different documents produced by defendant prima facie substantiate they are in possession of two sides, whether those two sides are very same sides in which plaintiff laying claim or to the different site is required to be determined by the trial. It is vehemently contended by the learned counsel appearing for the defendants that when the defendants are liable to show the existence of their two sites, the existence of site numbers claimed by the plaintiff is highly improbable. The same can be determined only after the trial. Lord, may kindly look at the schedule and my schedule. My schedule, site number 20 is 40/19. Their contention 120/20. 120/20 and 40/19 are both are one and the same, Milord. Highly impossible because the site number 1 and 2 they have stated para 38 may
That's
kindly.
what the court also said, highly improbable.
Yes, Milord, my submission before the court is that when the tours.
No, it is. Now you assert your title by way of some.
Yes, Milord.
They are also asserting the title.
Yeah, absolutely.
So that the numbers are also, his numbers are 1 and 2, yours is 20.
20.
Now, according to you, they are interfering with your position.
Yes.
As it is, nothing would be there to for the court to ascertain it.
Milord, that is the matter of trial is that is the matter of trial is concerned, Milord. When there is a sale deed and there is a possession transferred and earlier, Milord, their possession of 1956 is altogether different. My possession is altogether from different. My boundaries are specific.
So how both of you, where is that overlapping and where is this encroachment?
Therefore, page 38 of the written statement kindly look at, Milord, please. 38, last 6 lines, Milord, in the written statement defense.
According to the court, prima facie case is your sale deed.
Yes, Milord, the court comes to conclusion.
He also has a prima facie case of sale deed.
That's finding is error, and if the once court comes to conclusion, plaintiff is made out a prima facie case, court ought to have granted an injunction. Milord, page 38, Milord. May I read the last 6 lines, Milord?
Page number?
38. 38. It is the written statement defense. From bottom 7th line, Milord, I am reading. The word started, the defendant being the owners of property bearing number 1 and 2, 27th Cross, Jayanagar, Bangalore, thereby bearing number 1 and 2, measuring 120 into 20 feet. Originally, property bearing was granted Patel Sitaramaya by village panchayat, so and so, and property number 2 was purchased on 5 April 1956 from Anantaramaya, who was allotee of the Achamma and the mother of the defendants. The copy of the sale deeds are here with produced indicates the western boundary of the property number 1. Actually, the property of number 1 and 2 are acquired by CITB, and the compensation was granted as per the property when they take into this is their defense. Please kindly look at 120 into 20 measurement and schedule property. Kindly look at page number 29. Page 29, plain schedule.
Anyhow, there is an order of status quo, maintain status quo, let others come.
That's we are challenging before the court. Once I made out a prima facie case, court ought not to grant it. Status quo will
Then that the court shouldn't have said prima facie case then.
Milord, they have sailed it only. Milord, that is the error. That error we are before the court.
No, that's why we'll record that without there being a prima facie case, court said it's a prima facie case.
Notice to the
one side court
respondent.
held, my lord, is
Notice
having
to
a
the
title.
respondent. That's not a case where the court can grant an injunction. The notice to the respondent, same. If the memo is filed by 21st, post is marked on 23rd.
Correct.
Yes.
Cell number 29, yes, Venkat Subbarao for appellant.
There are two connected matters between same
I appear
party.
for respondent number 1 and 3, my lord.
Post along with so and so on 29th of October,
It's a fresh matter little earlier.
on 16th.
Great.
Cell number 30. Reader G.
At the request of learned counsel for the appellant. Yes.
I appear for the appellant, my lords. This is the defendant's appeal against the order of injunction granted in favor of the plaintiff. The plaintiff claims that he is the owner of a particular property, number 27 PID so and so, 3rd Cross, Yedur. He has purchased the property under a sale deed of 2011. The defendants entered appearance and they are claiming title to a property which is different, 27/2, which is on 2nd Cross. That is the defense taken by the defendant. They have purchased the property in the year 1997 in 2 portions, brothers, and they have amalgamated it in 2006. The court notes that the 2 properties are different, that there is no iota of doubt that the plaintiff's property is different from the defendant's property. But on the mere assertion by the plaintiff that there is an attempt to interfere, an injunction is granted against me. Now, even in the impugned order, there is a specific observation that this should not be construed as interfering with the other property. But under the guise of that interim order, now the plaintiff is trying to interfere with my possession and therefore I am constrained to file the appeal.
Let's see the order.
The order starts at page 12, my lords.
Come to the reasoning part.
Reasoning starts from page number 19. May I read, my lord? The plaintiff has filed a suit for perpetual injunction claiming that he is in possession of the property and defendants are interfering with possession and enjoyment of suit scheduled property. Suit scheduled property is non-agricultural land
When
described.
was it purchased by the plaintiff?
Plaintiff purchased it in the year on 13/6/2011. The schedule of the property I'll skip for the
Yes,
present.
yes.
The plaintiff claims that he has purchased the property, whereas the defendants contended that they have purchased their property on registered sale deed from Chinnamma and they are in possession of the property. The defendants have contended that since there is a dispute regarding title, the suit for injunction simpliciter is not maintainable. In order to establish prima facie case, plaintiff has produced documents. I have perused the documents produced by both the plaintiffs and defendants in detail. The plaintiff has produced sale deed dated 13/6/2011. As per sale deed dated 13/6/2011, Muniamma, represented by M. Kannan, has executed sale deed in favor of the plaintiff in respect of property bearing number 27, municipal ID 1/12, PID so and so, situated at 3rd Cross, Anjaneyya Temple Street, Yedur, measuring east to west 98 and north to south 35 feet. The property described in the plaint as well as the schedule of the sale deed are one and the same. The plaintiff has also produced power of attorney executed by Muniamma in favor of Kannan. Power of attorney executed by owner Muniamma is registered in the office of Sub-Registrar Jayanagar. It is clear from the power of attorney that M. Kannan was authorized to sell the property for and on behalf of Muniamma. A registered rectification deed executed on 23/6/2011 shows that there was some mistake in the road name mentioned in the power of attorney, which has been corrected. It is clear from the document maintained by BBMP that after execution of registered sale deed, name of plaintiff has been entered in the property extract pertaining to number 27. BBMP has issued Khata certificate and certificate showing plaintiff is the owner in respect of suit property. I have produced the documents produced by the defendants also.
So your vendor is common vendor. For both of you, vendor is.
No, my lords.
No, it's Chinnamma.
That is Muniamma, my lords. Plaintiff's vendor is Muniamma, defendant's vendor is Chinnamma, and plaintiff's vendor claims title through a group panchayat,
Yes, yes.
sale certificate.
Yes.
Para 8, my lords. I have perused the documents produced by defendants also. Documents produced by defendants show that the defendant number 1 purchased property number 27/2 situated at 2nd Cross, 6th Block, Yedur, Jayanagar, measuring 55 feet east to west and 30 feet north to south as per sale deed dated 18/2/97 from one Chinnamma. Likewise, defendant number 2 has also produced documents showing the remaining portion of property bearing 27/2 situated at 2nd Cross, measuring east to west 45 feet and north to south 39 feet from Chinnamma. These documents show that the name of the defendants are entered in the property extract pertaining to property number 27/2. The Khata extract clearly shows that the property purchased by defendant is old number 27, new number 2, whereas in the document produced by the defendant, the property is 27/2. If both the sale deeds are considered together, then the property purchased by the plaintiff is property number 27, whereas the property purchased by defendant is 27/2. The property purchased by second defendants are situated at second cross, whereas the property purchased by the plaintiff is at third cross. So the sale deed produced are with respect to two distinct properties, one belonging to plaintiff and another belonging to defendants. Apart from this, the written statement contents makes it clear that the property of plaintiff and property of defendant are different. Suit for injunction simpliciter is maintainable when there is no cloud on property. As per decision of the Apex Court in case of Antula Sudhakar, etc., where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without a consequential injunction is the remedy. Where the plaintiff's title is not in dispute or under a cloud, but he is out of possession, he has to sue for possession with a consequential injunction where there is merely an interference, plaintiff's lawful possession or threat of dispossession. It is sufficient to sue for injunction simpliciter. In this case, since the claim of the defendant is with respect to property number 27/2 situated at second cross, and the claim of the plaintiff being property number 27 situated at third cross, in my opinion, the claim made by both the parties are not in respect of one property, but two distinct properties. And there is no cloud over plaintiff's title. Since both properties of plaintiff and defendant are distinct and separate, the plaintiff has shown that he has purchased the suit property by virtue of sale deed and revenue records are mutated in the name of the plaintiff. In my considered opinion, plaintiff has shown prima facie case his possession over suit property. This suit being one for perpetual injunction, possession as on date of filing of suit plays importance, and since the plaintiff is shown to be in possession prima facie, in my considered opinion, prima facie case lies in favor of plaintiff. Property of the defendants are different, and they have failed to show that plaintiff is claiming right over the property. Apart from this, there is a triable case made out by the plaintiff as some of the boundaries are disputed. The finding is to be given after taking evidence in this regard as considerable time has lapsed after execution of sale deed in favor of plaintiff as well as defendants. The name of person mentioned in the boundaries might have changed due to subsequent acquisition. Therefore, in my considered opinion, plaintiff has also made out triable case. Prima facie case includes chance of success and triable case, and both have been shown by the plaintiff. Therefore, in my considered opinion, plaintiff has shown prima facie case lies in his favor. Since these 2 points are interrelated to avoid repetition, they have been dealt with together. While answering point 1, I have concluded plaintiff has made out prima facie case. Suit is for injunction and plaintiff is alleging interference by defendants. Suit property is a vacant site and if possession of property is interfered with.
The order.
Last paragraph, my lords, in the before point number 4, it is necessary to mention that temporary injunction is not an obstacle for defendants to enjoy property number 27/2, which they have purchased under 2 sale deeds as suit property and property of defendant are different.
No, it is like this. According to him, there is an injunction. According to you, he is owner of a property in third cross or second cross. You are on the other. So it's your case that you are not interfering with his position.
Yes.
And then in that case, if the injunction is granted, how are you affected?
My lords, I made the same mistake when ex parte injunction was granted. I proceeded on the assumption if I just place the facts, injunction will not be granted because I am not interfering. That is why now, after the injunction is granted, he is interfering with my property.
No. Now the court, now your properties are like distinct and different properties.
Yes, my lord.
So it is not that it's an adjacent property.
No, my lords.
No, under
Different
the case
process.
of it, he cannot because they're 2 different properties. How can he interfere with your property?
My lords.
Court has only granted injunction in respect of his property, not that the court has permitted him to interfere with your property. It is if the court can understand if both of them are adjacent ones, not even adjacent properties. So that's a whole basis for the court to grant injunction.
My lords, I have not even attempted to interfere with his possession because my property is different. If I were to claim title to his property and I am claiming that that same property is mine,
that
then
we will record and clarify.
yes, my lords. Also, my lords, if at all the plaintiff were to be claiming that the property owned by defendant in his possession is the property which I am owning, then my lords must consider that my sale date is in the year 1997
and
and 2011. So prima facie, if my sale date, I am in possession of the property and he is claiming that property, unless he asks for declaration, he cannot get an order against me.
You know, he's not asking. That's a finding of the court.
Therefore, my lords, when the 2 properties are distinct and I am not even making a claim to the plaintiff's property, where is the cause of action, my lords?
That is his suit. That's his case. You are saying that, no, I'm not doing anything. My property is different. His property is different. All that were considered and passed an order.
My lords, all that was considered, my lords, but then there is an injunction against me when I am stating that I am not interfering with his possession. At least my statement could have been recorded that, okay, properties are different and therefore there is no cause of action. There is no cause of action because I am not interfering.
That will be decided eventually in the suit.
Yes, my lords, in trial. But the difficulty because of which I am before my lords is that in the guise of having this order, 27/2 is trying to interfere.
That we will record.
I have not filed wakalat in this matter. Kindly have it on Monday, I will file because.
That will dispose of the matter.
Yes.
The land counsel, so Mr. Vijay Kumar, submits his instructions to file wakalat. Post this matter on Monday.
Yes.
On that day, the matter will be disposed of.
Yes. Much-
Number 31, Jayaprakash Reddy M for petitioner, Prasanna Kumar.
For the respondent,
For respondent.
my colleague has some inconvenience today. This matter may kindly be taken up.
How many times this has to be listed? On one reason or the other, it is getting adjourned. When there will be convenience for your colleague?
Because this is a case for me is a pro bono case, because she is a lawyer
Understand.
colleague.
So every time you're inviting the senior counsel to come, you should have informed him at least.
We have informed, my lord.
When, madam?
My colleague informed,
Monday.
please.
Yes, at the request of land counsel, the respondent finally on Monday, no further adjournments will be granted.
I think it may be come in the top of the list, otherwise your lordship can see it may not be
That's, Monday is the last working day, and Tuesday, not Monday, Tuesday.
Tuesday.
Even the other matter also, on that Monday, that contempt one I posted, no, not Monday, let it be on Tuesday. Tuesday.
Please, ma'am.
This matter also on Tuesday, not on
Tuesday,
Monday.
please.
Before matter also. Any of the matters have you taken on to Monday, all that on Tuesday.
Till number 32,
Anita, tell the others also. Any matter that is posted on, I was under the impression that it is Tuesday. That is- Yes,
Serial number 32, I appear for the respondent.
he seeks time.
Radha Y,
At the request of land counsel, the respondent poses matter on
Uh,
29th of October.
Little early, ma'am.
29/10.
Kindly little early.
Till number
Middle week in the month.
What is this?
Middle week in the October, 21st.
You want it on 21st?
Yes.
21st.
Great.
21st, my lord.
21/10, sir.
Very
Till
well.
number 33, E. Suguna. Sudha. For petitioner, YD Harsha for respondent.
Petitioner wife.
Where is the husband?
Married.
Respondent advocate.
My lord, this is the impugned order is annexure A, my lord. I challenge portion of the order.
Because anyhow it's 2020 RPSC, counsel is not there. Finally, it has to be heard.
Yes, because my, I was denied the maintenance, not granted in my favor, my lord.
Coming up.
Only
with
my
the-
daughter has been granted maintenance.
Hmm.
So even though I have produced a salary certificate, that was not considered at the time of passing.
No
this order.
representation on behalf of the respondent. Counsel for the petition is present. Poses matter on
Lordship, may kindly fix the date. when-
4th November.
Till number
Much
34. Guru Rajesh.
This also no representation for the appellant. Yes.
411. Till number 35,
35, I appear for the petitioner, my lord. That I am informed that, my lord, that they have already obtained a divorce. They have settled the matter. That, based,
That it is submitted that the parties have settled the matter. They'll file a memo in that regard, post this matter after vacation
please, my lord.
on 22nd of October.
Oh, bless.
till number 36, Bhushani Kumar for petitioner.
Appearing for respondent.
Yes, your lordship.
Hmm?
Lordship, today, we have transferred rupees 1 lakh to them. And this matter is likely to be settled, your lordship.
Is it so? They have-
Actually, my learned friend has actually conveyed the 1 lakh will be transferred today.
No, she says already transferred.
Yes, your lordship.
50,000 is already transferred.
50,000, it will, due to the limit, it will be transferred after 24 hours. We have already transferred.
Hmm.
So it is likely to be settled a day.
We'll have it on Monday.
No,
So
Your
every day, no, every day limit 50-50 you transfer, we'll hear it on Monday.
No, your lordship. Matter is likely to be settled. Kindly, it may be
It is
listed
submitted that
after
today they've
21st
already
October.
transferred 50,000 and another 50,000. They'll transfer it by tomorrow. Tomorrow, post this matter after vacation on
After
21st of October.
Yes, your lordship. Grateful, your lordship.
37, Kantraju NK
I'm appearing for the
for
petition.
petitioner. E.
Yes, your Lordships have directed me to produce the list, memo of calculation.
For all the advocates, a vacation mood has come. No representation for the, as per the order passed by the court.
Well, this
Cali-
order,
ex parte order, that has to be set aside and remanded back to the
But,
family
he has to
court.
be there. Inform him, we'll take it up on Tuesday.
Please, Malas.
Post this matter on Tuesday.
Oblige.
No representation for the respondent, counsel for the petitioner is present before the court. And also a calculation memo is filed before the court today. Yes.
Cell number 38. P. Ravindra.
Lordship, I bear for a respondent, Lordship.
Yes.
We will file objection in 2 weeks, time may be granted, Lordship.
You have stay in your favor?
Petitioner, I am for petitioner. Page is for admission.
No. Any interim order in your favor?
No, ma'am.
You are the wife?
I am for wife.
Seeking enhancement of the.
Not
Who-
enhancement. My petition has been
Itself is
dismissed.
dismissed. Who moved this memo?
I only move.
You moved?
Yes.
What do you want in this for 2024 now?
Admission.
The counsel for the respondent submits that he'll come up with objections. Post this matter after vacation on 11th of November.
Cell number 39. Edgar Ramakrishna is for.
Respond for 1 and 2, my lord.
Devraj
They have
E.
not served a copy. Not received any
I'm
copy.
sorry, copy is served.
No. Received only and summons, my lord.
I will.
Any interim order in your favor?
Yes, please.
Counsel for the petition is permitted to serve notice on the counsel appearing for the respondent. Are you complying with the interim order?
Please.
It is submitted that they are complying, they have already complied, they are complying with the interim order passed by this court. Post this matter on 12th of November. Yes.
I will serve the one set of court. Today I will.
Serve him.
Yes, yes, please. Okay.
Yes.
Interim order, my client.
Interim order earlier granted is extended till then.
Yes.
Yes.
Cell number 40.
Respondent.
Lords, they filed an application seeking vacating of stay, my lords. The interim order that is granted by this court is that we are only permitted to lease or rent the property because I am in possession of the property, he admits it. Now they are saying that in the vacating application that we are creating third-party interests. No documents are produced to show that we are creating any third-party.
Anyhow, the MFA has to be heard.
Please, my lords. My lords, it is the case of the plaintiff that the property originally belonged to his grandfather by name Susai. And he has executed a gift deed in favor of his grandson, that is the plaintiff, under a registered gift deed dated 7/4/2018, my lords. He says that I am the son of Susai, the grandfather. I am the uncle of the plaintiff. He says that I am in permissive possession of the property. The grandfather died on, he died on 11/8/2016, my lords. No, sorry, my lords.
How can the gift deed be thereafter?
Sorry, my lords. He died prior to, I don't know the exact date, but what has happened is, in the property that is gifted to the plaintiff, the survey number is wrongly mentioned. But he gets a gift deed executed by the wife of Susai, saying that the property that is gifted to him under the gift deed is the property which is the suit schedule property. I claim that my father has executed a gift deed in my favor under a registered gift deed dated 27/2/2013. That is
In
the
respect of this property where
same
you're
property.
staying.
There's no dispute with regard to the survey number. So this is the only dispute, my lord. He wanted an injunction restraining us from doing anything with the property. We approached this honorable court permitting us to let out the property, lease or rent, and that is the only order that is passed, my lords. My lords, admittedly, I'm in possession of the property. Prima facie documents show that.
Yes, yes.
Please, my submission is, blanket, my lord, there should be some accountability. What is he is going to lease? What is the rent he is getting? Because I have also claimed for damages in the suit. He cannot.
But you can file the same before the court.
Yes, let them file
File
what are the
statement
rents
before
they
the
are
court,
receiving,
like, to
whom it has been let.
Please, my lords, I will file a statement about what is the
According that
property. what-
with that we'll dispose of.
Yes.
That she can let out, she can lease
Will
the
not
property.
with
And whatever is
They should submit accounts to
the
the
rent
court.
is deriving out of it, that should be accounted before the trial court. Yes. Agreed with orders passed in I number 1, invoice number 1605/2023 dated 26th October 2023. The defendant is before this court. The plaintiff had filed a suit for
For
declaration.
declaration, I am the owner of the suit schedule property under the guise of the gift deed executed by grandfather. in
And
the year
also for
2000
damages.
And also
recovery
for
of pos-
possession and damage.
Has filed a suit for declaration, recovery of position, and for damages. In that, he have filed an IA number 1, seeking a temporary injunction from alienating or encumbering the property by way of gift, sale, mortgage, lease, rent, lease in favor of the third parties. The trial court had allowed this application and restrained the defendants from alienating or encumbering the suit property by way as sought for by the plaintiff. Agreed thereby, the defendant is before this court. And this court by order dated 21/12/2023. This court has granted interim order whereby the order dated 26/10/2023 passed by the trial court is stayed subject to the condition that the appellant defendant is permitted to only lease or rent out the scheduled property till the next date of hearing. The plaintiff, the relationship between the plaintiff and the defendant is plaintiff is the nephew.
Please.
Plaintiff is the nephew and the defendant is the junior or senior paternal uncle.
Junior uncle.
Defendant number 1, my lords.
Defendant number 1.
Is the junior paternal uncle of the plaintiff. It is a case of the plaintiff that the suit scheduled property is gifted to him by his grandfather by gift deed dated 7/4/2018.
2013.
13.
Lord, for
13
my
is,
gift deed is first.
Huh?
Lord, this gift deed is executed in my favor is on 27/2/2013.
27?
2/2013.
Is
I claim
execute-
ownership under that gift deed.
And I think you have said the other way.
He's
Mine
the
is-
subsequent one.
Subsequent, but my lords, what I've said.
No. How you have submitted it, like first is yours, second is his.
No,
Please, my
his
lords.
gift deed is 14/2/2015.
There is a mistake
That
in my
executed a
opinion.
gift deed in favor of the plaintiff on 27/2/2013. 13, and the uncle is in permissive possession of the property. It is a case of the defendants that his father has executed a gift deed in his favor on 7/4/2018,
No,
where
14/10/2015.
14/10,
2015.
7/4, defendant number 1 has executed another.
14/10/2015.
Please.
2015. And in fact, in the defendant, in the gift deed that is executed by the grandfather in favor of the plaintiff, the survey number of this house is not mentioned.
It is
There-
mentioned. It is wrongly mentioned, my lords. There is a survey number.
Wrongly mentioned.
It is wrongly mentioned. And later, the grandmother clarifies by way of a document that it is one and the same. It is a case of the defendant that even it is, according to the defendants, the plaintiffs have also admitted that they are in possession of the property. The trial court, while allowing this application filed seeking injunction, have observed that on careful comparison of the boundary particulars of the property, one involved in the gift deed relied on by the plaintiff as well as the gift deed relied on by the defendant, prima facie discloses that the boundary particulars of the property involved in both deeds are one and the same, and property number only differs. Whether the plaintiff as well as defendant number 1 have acquired right over the suit property on the basis of respective gift deeds relied by them or not is to be decided only after a full-fledged trial. By taking into consideration the nature of the suit and the dispute involved in the suit, The preservation of the suit property in its existence till adjudication of dispute is very much necessary. And the court felt the plaintiff has made out a prima facie case for the grant of injunction, accordingly restrain the pastor injunction, restraining the defendants. Next, land counsel appearing for the appellant defendant submits that the defendant is in possession of the property. And it is also admitted case of the plaintiffs. The trial court had failed to consider these aspects and restrain the defendant from mortgaging, encumbering, or in any manner dealing with the property. It is submitted that if by passing such an order, lot of inconvenience is caused to the defendant. And in fact, balance of convenience lies in his favor as he has been in possession of the property. It is submitted that this court had permitted the defendant to lease
and rent.
Operation of the impugned order said, subject to appellant is permitted only to lease or rent out the suited property.
1 million.
The order dated 21/12/2023.
The appellant was is permitted to lease or rent out the suit property till the property. It is submitted with the land counsel that the same order may be made absolute in the interest of justice. Next para, land counsel appearing for the respondent plaintiff submits that considering the gift deed, which is much prior to the gift deed of the defendant, the trial court had rightly granted the injunction. He submits that he has even sought for as the defendant without any manner of right and title is enjoying the property. The plaintiff has also sought for damages. Now, if this order is made absolute and the defendant enjoys the property in the manner in which the defendant wants, and there will not be any accountability. And in the event the suit is decreed, it is very difficult to ascertain the damages. Next one. And he submits that the appeal is liable to be dismissed. Next one. Having heard the counsels on either side, there is some material on record. Both the parties are plaintiff and the defendant are related. Plaintiff is a nephew and the defendant is the uncle.
First
Both
defendant.
of
First defendant, there are two defendants.
first defendant is uncle. The plaintiff and the defendant are both relying on a gift deed that is executed by the grandfather and the father. There is with regard to the number, what is that number?
Survey number,
Not survey number, it is
property
house
number.
number,
Property number.
property with regard to property, number of the property. There is a dispute. The plaintiff suit is for declaration, recovery of possession, and also for damages. The trial court went wrong in granting injunction, restraining the defendants from using the property as admittedly he has been in possession of the property. If it is the court wants the property to be protected till the suit is till the suit is disposed of, some order, a balancing order ought to have been passed by the court. This court by way of an interim order had permitted the appellant to lease or rent out the scheduled property. In the considered opinion of this court, this order is a balanced order whereby it will not be both the parties. The property will be preserved and no third party rights are accrued. And in the event the suit is decreed, the property is very much preserved. But as rightly pointed out with the accounts for the respondent, unless and until the property that is leased out and those account that unless there is a proper accounting of the same, then in fact the plaintiff would be deprived of his his right and the ascertainment of the damages. In that view of the matter, this court is disposing of the appeal in the following manner. The order of the trial court is dated, trial court in I number so-and-so, in OS number so-and-so is set aside. And
Right. Not to alienate is also there.
Huh?
Not to alienate is also there. That remains as it is.
is modified. The order of the trial court is modified. And the defendant is only permitted to lease, rent the premises, number one. Number two, she shall, the particulars, with regard to the lease and the lease oblique rent and the rental that she is deriving of it, it should be properly accounted and shall be placed before the trial court from time to time. Accordingly disposed of.
Cell number 41, Raghavendra C. for appellant, Nandakumar T.M.
Yes.
Just may kindly recollect. My lord, I have filed 2 applications for condonation of delay yesterday in the office.
How much is the delay?
6 days, my lord. 6 days. Filed it in the office, not been put up.
Even that also,
Lordship.
you don't appear before the court, number one. Next, even for filing a petition also, when is this matter adjourned? When is this matter? And the last occasion, when did it came?
My lord, on Saturday, my lords, due to paucity of time, it was now adjourned to today.
Yes. Let's hear him.
Only for a moment, my lords. Your lordship may kindly, the caveat copy is available on the file. What the affidavit, the person who is coming before this court is filing affidavit is one Mr. Jagdish. For a moment, wakalat may be kindly looked.
Give that, give that.
The caveat petition may be kindly looked into. That should be in the file. What signature he had affixed, the same name was reflected in the cause list. And he should have come and filed the affidavit before this court. One Jagdish is coming and filing affidavit.
He is also on wakalat, my lord.
Your lordship may kindly see the wakalat. When your lordship may kindly pursue the wakalat, my lord. Nandakumar TH. The signature is Nandakumar TM. The office had noted the name of Nandakumar TM. Even the Jagdish signatures are coming later. The pen is handwriting is different. Now Jagdish is coming and filing affidavit. Nandakumar should have come and filed the affidavit. That is a case where Nandakumar's name TH has been reflected, not TM was reflected. If Nandakumar should come and file an affidavit, where is Nandakumar? There's a question which I'll have to post for myself. Where is Nandakumar? Nandakumar should come and file an affidavit because that is the case is that the cause list name is Nandakumar is perfect. Only TH and TM was a difference. Let him come and file affidavit. Why Jagdish is coming and filing affidavit? And his phone number, since then till now, this phone number is not in existence. The phone number which is noted in the wakalat. Because only I'm stating this before your lordships. The appellant, the plaintiff before civil court has adopted all these statics in all the civil cases, filed various civil cases for have different lawyers, and those lawyers would not, their address would not be in existence. What all cases which are?
Phone number is this?
Lord, it was written by my clerk, which is a wrong number. It does not pertain to my number, Lord.
Why he has written?
Lord, instead of 974, he has written
What is
947.
this tactics? You file a caveat, you give your number, and you tell that the
Lord,
advocate
it
has
was
given
not
some-
sent to my phone number, my lord, nor it was sent to my address mentioned herein.
And then the
It
number
was-
itself is not existing.
Lord, it was sent to my email address.
No. Why
Which
should
is
a
not there
phone
in his
number?
wakalat.
Why should a phone number?
Lord,
That's why he's saying that.
Lord,
No,
that-
this is not existing.
No, not no, he's admitting that. He's
No,
saying
I'm
it's wrong. How
admitting
can
that.
the
Why-
wrong
I
number?
cannot even deny that.
Why
I
should
certainly
it-
cannot deny that.
Why should it be given?
Lord, it was a mistake on part of my clerk. A mistake on part of my clerk, my lord. That cannot be subject.
No, everything can't be a mistake.
Lord, this is only the mistake that's on part of my clerk.
Then
I
Nandakumar,
fail to
Nandakumar
understand,
is
Lord.
the advocate, like TM or TH has filed the wakalat. Where is he?
Lord, he's present, my lord. He's also here.
Has he filed the affidavit or whatever it is?
Lord, he has filed. Lord, it is the same office, my lord. On that day, on filing the affidavit, due to some urgency, he was not there. Lord, instead, my lord, the person who was there on the wakalat was also my colleague. Lord, he has filed it.
No,
Lordship
no.
may kindly,
No.
Lordship may kindly bear with me for 1 minute. Lord.
Yes.
Lord,
can a notice or a summons or a copy be served through email address, which is not in existence, and submit before the court stating that, no, I've already served the copy, he is not present, therefore, please kindly hear the matter, my lord. That's my one.
Is it not, is it right on your part to file a wakalat, which the name cannot be understood, the number cannot be found?
Lord, that's a part, that's
First
a.
of all, the first you have to
Lord,
answer
Lord,
that.
that's a
then to
mistake.
go further.
Lord, that's a mistake on my clerk, Lord. Nevertheless, Lord, the address is correct. It's still in existence. It was always in existence from 10 years. The address is correct. He ought to have sent a notice.
Let's not go into this. Let's
Obliged.
deal with that,
Right.
so that, yes. Please come to the order. What is wrong with the order passed by this court?
Lord, I need to file his
No, no,
written
no.
statement. His written statement, which is not a part of the document, because
No, you can pass on it.
Lord, I'll file my statement of objection. I will only be permitted to file my statement of objection when this order is recalled. That's my.
No, that will not be recalled. We will
Dehouse
hear it
this
at
order.
the point.
Dehouse this order, my lord. If my lord would say, yes, I can file my statement of objection, I would be definitely filing this
Objections you will file.
for the
Court-
MFA, my
no,
lord.
I am looking at the
Please.
order that is passed by the trial court.
Certainly, my
And
lord.
basing on that, this order is
Certainly,
passed.
please.
What objections are required in this?
Lord, he has not filed.
I have
Lord-
not looked into any other document except the documents that are there.
Lord,
before
in the
trial
MFA
court.
copy, in the memorandum of appeal, his written statement is not forthcoming, which I'll have to place it on record because
that is,
So kept it by this time.
is there before
Lord,
the court.
I will not be permitted to file that, my lord.
That is there before the
Fine,
court,
no,
my lord.
you-
I've given it to
Pass
the
on to
court.
the court.
I've
Lord,
given
it's
it-
not a part of the document.
No, it was gone to the court.
How
It is gone to the court. It is there in the court.
is telling that?
No, it is there in the court. Lordship
How is
pursued all
telling?
these things, only the order was passed. It was there,
How is telling?
it was there
Wait,
before the court.
Lord,
You can argue.
Lord, I'm instructed to engage a senior, my lord, to that effect, Therefore, I request your lordship to say, dehouse this order, dehouse the recalling order. If my lords permit me to file, my lord, it's already ready, my lord. I'll only need to get the signatures. I'll file it tomorrow or Monday. Lordships may have it on Monday. I'll let us my arguments, my lord.
Let there not be any order. Let him come and argue on Monday, my lord. Because immediately, very shocking. Just showed you.
No, no, no. Every.
His father
the-
has gone in interim order
the
after 10 days.
client- The client, the
Not even a
respondent-
single rupee is
one
transferred to
minute,
my
the
account
respondent,
out of the 15.
The respondent, for any of the lapses or any, if the court finds that it's been,
Yes.
they've been playing with the process and this is how they have been taking advantage of anything, exemplary cost,
Obliged.
running into clacks will be imposed,
Monday.
not
Yes,
one
my
lakh.
lord. Also, please kindly note, out of 15 crore, not even a single rupee is transferred to my account till date.
Yes, yes, we will see that. Yes, next, pose this matter on Tuesday. This matter on Tuesday on the top of the list.
Obliged.
I maybe have
Cell number,
serving the liberty to file the statement of objection.
No, you can come, you can give it to the court, no liberty. On that day, you can pass on.
Great.
Yes.
cell number 42.
For the appellant in this matter,
Okay.
there is a delay of 98 days in filing this.
Notice to respondents,
Cell number
post after service of notice. Yes,
43. Pradeep Kumar.
no representation, post after vacation on 11th of November. Yes,
Cell number 44. Azimuddin.
let's see some IA 1/24 for paper publication, will order. Hmm? Nothing is written. No representation for the petitioner. Pose this matter on 12th of November. Next.
Cell number 45. It is Rajavani.
Appear for petition. Kindly allow IM for paper publication.
The application is filed. Take out notice by waiver substituted service on the respondent in Prajavani, Kannada, Delhi, Mysore edition. Accordingly, IA is allowed and the petition is permitted to take out notice and on so and so, on which date?
In 10, hearing on 24/10.
Yes. Yes.
46, PK Sampath Kumar, Suraj Sampath.
Appealing for the petition. My lord, senior is upon his legs in another court.
My lord, there is an interim order prevailing in this matter from 2021, my lord. I have filed a petition under 13(1)(a) against my wife, and that has been stayed from 2021, August 19th.
In this case,
Please, my lord.
how can it be?
Lord, there's a stay on proceedings granted, my lord.
Why?
I have filed a vacating stay application, my lord, that is
Lord, they had
pending
filed
for
an
your
IA
lordship's
under section
consideration.
What is an order? That is, what is the order passed by the court on maintenance?
Please, my lord, it is dated 17th September 2021, my lord, wherein the interim order was granted staying the proceedings in MC number 6930 of 2000.
We'll vacate that order. Why should the proceedings in the MC be
My
stayed?
my lord, there has
You are
been,
for the wife or respondent?
and the wife, my lord.
my lord, I am
Main-
the husband.
Maintenance is not paid.
My lord, I am paying up to
Challenge,
date
he had filed
maintenance.
an IA under the trial code, my lords, under section 24, seeking for an interim compensation of rupees 1 lakh. So there only 15,000 was granted. In regards to that, we had challenged that order and get.
In
permission
that
of-
My lord, I'll
case,
just
why
brief-
should the proceedings be stayed?
My lord, I'll just
But
brief your
regarding
lordship
that-
in
No,
2
no.
minutes.
But regarding that, like, senior,
No.
it's a short
No,
password
senior.
also.
My lord, I have been making payment of interim maintenance from the institution of the case till date, up to date, my lord. Even this month I have
In
transferred.
a
rupees
case of
15,000.
enhancement, why should the proceedings be stayed? What
Please,
purpose?
my lord, kindly vacate the interim order. At least let me be.
Short passover, senior will come make submissions regarding that itself.
My lord, there is nothing to be
Tell
submitted.
your
Last
senior
We
that
are-
interim order will be
But it's-
we are
vacated.
paying
What
the
date?
maintenance, my lord. It is up to
If both
date.
of you want to argue, then argue.
My apologies, my lord.
I will leave, my lord.
Pass over, let your senior come. Tell the senior, at the end of the list, I'll vacate the interim order and let the court proceed with it.
Please,
If you
my lord.
want enhancement, it will be decided by the court. Why should the proceedings be stayed?
Please, my lord.
Yes.
Oblige.
Cell number 47, Arun Govindraj.
I would kindly request password that senior is reaching in 5 minutes, my lord. There is urgency in the matter.
No, what is the time?
And
How can
I
a
asked-
senior reach, you ask for 5 minutes at 4:34.
No, he's coming from civil court, my lord. I'm requesting password.
Court can't help it if he comes from civil court or criminal
Have
court.
it on Tuesday, my lord.
No, my lord, because 13th of school fees, the last date is there, my lord. Request
What
for
to do
urgency.
when you
I
people are
request
not?
password, my lord.
Yes, next matter call.
Cell number 48,
I'm for the respondent wife in this matter, my lord. On the last hearing, the lordship has directed that the child be assessed in Nimans. Still, the proceedings are going on. They need another 3 weeks.
Let's
So
see
that-
the.
Now they've been called on the 26th and 28th.
Hmm. When they are next, when is the appointment?
26th and then 28th. And then they need another 7 sessions with the child because they're assessing the child for IQ, EQ, analogy, and also for autistic, any exhibits of autism.
Yes.
Please, Your Lordship, no objection to that proceeding.
Then,
only if his usual visitation is on Saturday, Lordship, if Lordship's all right, on first it could be taken up so that what happens on those 2 dates, they could report.
No, it says
They
26,
want
28.
further.
After that,
Another-
there are 7 sessions.
Another 3 weeks is needed, my lord. As
Another
per
3 weeks. That's what they say.
Please, Your Lordship,
So,
until such
like,
time.
it is submitted by the land counts for the respondent mother that on 26th and 28th also they're having sessions before the NIMHANS and further another 7 sessions are required. Pose this matter, once a report is placed by the NIMHANS. Therefore, in the meantime, what about the visitation?
We have
In the
no
mean-
objections in the mall, my lord. As per what is done the last time. In the mall, he may be permitted to meet, my lord.
Your Lordship, it's undoing what Your Lordship's earlier order is. Last week also we conceded only.
Till the case is listed, the father can exercise the visitation on Saturday between 1 PM to 5 PM at Meenakshi Mall.
Correct. The order before that, Your Lordship had passed, we had even reported it. Child's very happy at home, eating, feeding, she's playing everything. Last
Can
week.
you, like, we are at this, with the verge of that assessment, till the next date of hearing, on every Saturday between 1 PM to 5 PM. The father can exercise the visitation at Meenakshi Mall and the mother shall bring their daughter to the mall.
Your Lordship, the Dashara vacation, Your Lordship.
Until the report is placed, my lord. We don't have any objections until the
On
report
every
is
Saturday until the report is
Please,
placed.
Published.
the child's birthday is on 7th, Your Lordship, 7th of October.
Seventh,
7th October.
on 7th October.
And
Saturday 1 to 5 also he may meet, my lord. I've spoken to him. 1 to 5 he may meet the child on that day. We'll bring the child to the
seventh-
Your-
on
the-
either
on
to
4th
Meenakshi Mall or Vega Mall, my lord.
Your Lordship, on 4th is his birthday and on 7th is the child's birthday. Those 2
Seventh,
days.
first, 7th October, same from, what did you say, 10 o'clock, 11?
1 to 5. Same orders as 1 to 5 at
five
Meenakshi
in the
Mall
same- in the
or
same-
Vega Mall, my lord.
And when is his birthday?
On 4th, Your Lordship,
4th of?
October.
Uh-huh.
And
4th of
7th is
October
her
is
birthday.
also a holiday. Same times on 4th of October on the birthday of the father. 7th of October is the birthday of the girl.
Please. Your Lordship, might I request the matter be taken up as part heard? Reason being, Your Lordship has met the child, spent extensive time. Yeah, I understand it's a
Next,
burden, but
then what will happen for the next 2 months? I'm going to Dharwad.
Your Lordship, online we will apprise Your Lordship.
I think every day I have to appear online with all these parters.
Your Lordship, we shall not unnecessarily.
Lordship,
burden
once
your
the
public.
once the report is placed, we'll come before your lordship.
Please, please. Until
What
such
is-
time the
what
this
is 7?
will continue.
The parted.
Obliged.
Cell number 49 urgent,
48.
Obliged, my lord.
Smart. Yes.
49 urgent, 50. Rajesh, KS.
After the report is placed. 50, no representation for the petitioner. Was this matter on 19th of November? Yes.
Pass over in list number. List number 2. List number 2, cell number 1. CH-21 Rao, MD Chandrachudha.
Where is he? He wants to argue on the maintainability. Is it the case?
No, not a question of maintenance. Defendant is before this honorable court. There's been an injunction which has been granted in the suit.
No, where is the counsel? I'm saying, Mr. MB Chandrachudha. This court case has undergone adjournments on several, at least 7. Okay, again, a request is made for the adjournment to pay to the advocate. The adjournment is granted. Both this matter on under the caption dismissal. The appeal shall stand dismissed without further reference to the court. What had happened? Is
The
it paid?
costs have been. costs-
Yes,
Now, my lords, it was a case where my lords, an injunction has been granted.
you have an interim order in your favor.
But it's in the nature of a status quo now. So it has to be in the nature of a status quo. Now, my lords, basically what has happened, my lords, is this was a land, my lords, which fell within the ambit of a grant land, my lords, for which the PTCL Act would apply. My lords, the grantee, my lords, sold the land in contravention of the terms of the grant, my lords, which led to initiation of forfeiture proceedings under the.
Shall we have it on Monday, Tuesday? He's not there. Ask for the
Very
response.
well.
No
Not under
representation
this
for them.
act, that is what.
It will
Very
be, it will be. You are present now.
Yes.
Delete from the caption for dismissal. As per the order passed by this court, it is submitted that they have already paid costs of rupees 2,000. Was this matter after vacation on 12th of November?
Is it possible on Tuesday? my lords? One
Tuesday. Post on Tuesday. If it is, we'll do. Otherwise, it will be adjourned.
Please.
Tuesday. Yes.
Cell number 2. Rajeshwara PN.
Give that. On 3/6/2024, there was no representation. The matter was directed to be listed for dismissal on 5/6/2024. And on 5/6/2024, at the request of the petitioner, again, the matter is deleted from the caption for dismissal. Then on 19/8/2024, there is no representation on behalf of the parties. And the matter was directed to be listed on 24/9/2024. Again, on 24/9/2024, as there was no representation on behalf of the petitioner, the matter is directed to be listed for dismissal today. Today also, there is no representation on behalf of the petitioner. It appears that he is not interested to pursue the matter. Dismiss for non-prosecution. Yes.
Mallikarjun.
For the petition.
Yes.
Lords, if my lords recollect, on the last occasion on 10th of September, I had paid 3 lakh via DD. I was directed to pay the remaining arrears of maintenance. I have questioned the order of maintenance, interim order of maintenance granted, my lords, by the trial court. 50,000 is granted. 30,000, my lords had said pay the arrears to an extent of 30,000 from the date of the petition, my lords. I've paid 3, remaining is 6.8 lakh. Since the petitioner had paid in the very same month, September month, he's unable to gather the funds, my lords. 6.8 is a very large sum, my lords. He may be permitted another 2 weeks, my lords. He'll do the needful. In the meantime, my lords.
We'll post this matter on Tuesday.
My lords,
Please understand,
no,
by that
I'm-
time, please understand what the court is saying. By that time, whatever you're saying, let it be filed in the form of an undertaking before this court by your counsel that's indicating 2 weeks, a particular day, that the remaining amount would be paid.
some time is what I was asking, my lords. My lords,
So,
my difficulty is
If
that
not 2 weeks, take 4 weeks. In 2
I-
weeks, how much amount?
very well,
In
my
4
lords.
weeks, how much amount? Let it be an undertaking by way of an affidavit.
Very well, my lords. My difficulty is that I'm not there in station on Monday and Tuesday, my lords. Can it be had Friday, my lords, day after tomorrow, my lords?
Friday court is not there.
It's
Milords,
on 14th then, my lords.
petitioner is saying that every month he is spending 1,20,000 on his expense. If he had kept some money during this time also, he could have paid the wife
Yes,
and the
you
child.
file an affidavit.
Yes, my lords. My lords, I must also indicate there are 6 cases pending between the parties. 4 initiated by the respondent wife, 2 initiated by the petitioner husband. The 2 which are initiated by the petitioner husband are that of one is GNWC for child custody and the other one is restitution of conjugal rights, my lords. Both are pending. I must also indicate, my lords, there's a Domestic Violence Act case which is invoked against the petitioner husband. The prayers made there are 1.36 crores as monetary relief, 1 lakh
Can you leave all
99,000
that? You
monthly.
file an affidavit by
I
Friday. If
understand,
you're
my lords.
not there,
There's
file
some-
an affidavit by Friday. We'll have it on Tuesday.
My lords, I'm not available on Monday and Tuesday. I'm sorry about that, my lords. Kindly have it on 15th, my lords, the very first day of reopening in that case, my lords.
Then file it on Friday. The matter will be listed on before some other court. An order will be passed. I'll record that.
It's on
You're
15th.
there on Friday. That's what you're saying.
Friday, I'm there, my
We'll post this matter on Friday. Let the matter go before the other court.
My lords, the other issue would be that the petitioner is in Dubai. He's the resident of Dubai.
he's on
Right from
bail.
2007.
Please understand, let him complete. Yes.
Right from 2007, he's been working in Dubai. The marriage is registered here in Bangalore, therefore the jurisdiction is here and it is invoked. My issue would be that to get an affidavit from the party by Friday, again, that may become a problem. Let's kindly have
He
it
was
on.
here on the last occasion.
No, my lords, he wasn't. He wasn't.
He was there in the court.
No, my lords, he wasn't. He's been working in Dubai from 2007. In 2021, his
So
employment.
he'll be happily sit there, engage an advocate and we will watch the show from Dubai.
Certainly not, my lord. Certainly
I
not.
think last occasion we had enough discussion. I think no more intelligence
Kindly
is
have
not
it on
required.
15th. Kindly have
More
it on
intelligence
15th.
is not required from this court.
Kindly have it on 15th is what I'm requesting, my lords. 15th, my lords, I'm going to get the affidavit and place it on.
Milords, the petitioner is not getting any monetary. He has been dragging like this forever.
The order is dated June 2023, my lords. Since then, 3
I
lakh.
think you can
50
read what is the order on for 24/9. So what is the purpose of again making some submissions today saying that you want time? Court is specifically said on that day. Or
My
that
lords.
you think that the court has forgotten what has happened on that day?
Certainly not, my lords. I bow down to the order passed on 10/9, my lords. My difficulty is that he is a freelance music teacher. He is unable to gather 6,80,000 in 15 days, my lords.
So what we do is let them have the execution, let the warrants be issued, let whatever they want to
Lords,
do.
they've
do.
already
We will dismiss
initiated.
it. We'll
Milords,
dismiss your application.
He has money to spend on his
Then the
expense.
matter may be heard on merits, my lords. Then the matter may be heard on.
Heard on merits, Milord. He
That's why we'll
says,
dismiss it. We'll dismiss this
finally it may
petition.
be dismissed, confirming the law court order, Milord.
In
My
spite
lords,
of.
I have two
Confirming
submissions.
the lower
I
court
have
order.
two submissions to
Yes.
make.
Yes.
In the assets and liabilities, the respondent wife has admitted to being employed and getting 61,000 as monthly salary, whereas the petitioner husband is earning 91,000. The trial court has granted an interim maintenance of 50,000 per month. My lords, my request is that 50,000 is on the higher side, because 61,000 is her salary and 50,000 from the petitioner's side. And the petitioner is having.
First of all, you have no interim order from this court. When you're not complying with the orders passed by this court, passed by the trial court, why should there be an adjudication on merits?
My lords, I am trying my best to pay the arrears, my lords. 2023 June is the impugned order.
Conveniently, you've been
My lords,
dragging on
let
this
me,
matter. How many
Kindly-
times?
just a
kindly the
moment.
petition may be
June
dismissed
20
confirming the
June
trial court order.
2023 is the impugned order passed. From June 2023 till this days, 14 months have been passed. 3,50,000 is paid. The amount from 2021, the date of their application, till the date of the order is what is remaining from my side. Therefore, this request, my lords.
How many times you'll make the request? How many times the court will?
He's not in a good shape, financial position.
He said that this would be the appropriate amount. Accordingly, court said only pay on that, not as per the order passed by the trial court.
Certainly, my lords, but then he's not unable to gather a large amount of 6.8 lakh in 15 days, my lords. That is why I'm before my lords seeking short indulgence, my lords. Kindly have it on 15. By then I'll take
Lords, how
appropriate
the wife of
instructions.
the children
If
live, my
the
lords?
affidavit is to
From
be, if
2021,
the affidavit is to be
under
placed on
this
record,
honorable
I will
court
place it.
passed
my lords.
orders, they had not paid even 10,000, not even 100 rupees, my lords.
So how many
Kindly it
orders?
may be dismissed confirming the trial court order, my lords. That is my humble request. He has not even filed his assets and liability affidavit also in the trial court.
That is
And
on
according to
record.
Rajneesh versus Neha, whenever the respondent does not file the affidavit, it may be taken.
Is it correct that your income of the respondent is 60,000?
60,000, but including that all that deductions all will come inside that. And then an amount will come, and in which she has no shelter also. She is living in the church premises under the mercy of the church with 2 children. She is giving very good education for the 2 children, my lords.
I would
She's,
dispute
teaching
that
the-
submission,
she's
my lords,
teaching the
because in
minimum
the domestic
about
violence
his
petition,
responsibility.
she has given a
Domestic
residential
violence,
address.
there also she has
The
not got
residential
any,
address which
she
is
has
found.
not filed
I'm
any
sorry.
application in domestic violence also, my lords.
What the
I'm sorry.
advocates are not understanding from morning to evening. If advocates are fighting like how the parties are fighting, it's very difficult for the court to
Court officer? Court officer?
ಸರ್ ಹೇಳಿ.
50 ಸೀರಿಯಲ್ ನಂಬರ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅದು.
50
ಸೀರಿಯಲ್ ನಂಬರ್ 50.
1911 ಹೋಗ್ಬೇಕು.
ಯಾವತ್ ಮೇಡಮ್ ಅವರ?
1911.
ಓಹೋ 1911. ಓಕೆ ಮೇಡಮ್.
Madam, second list of serial number 1. Madam, second list of serial number 1.
Second is serial number 1. Madam, ಯಾವತ್ತು 14th or 15th? Serial number 46, 14th or 15th? 14th. ಸಣ್ಣ ನಂಬರ್ ರಿಸರ್ವ್ ಇದೆ ಬರ್ದಿದ್ದೀನಿ. ನಾಳೆ ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಬರ್ದ್ರಲ್ಲ ಅದು ರಿಪೀಟ್ ಕೊಡ್ಬೋದ ನೋಡಿ ಕೊಟ್ಬಿಡ್ತಾ ಅಷ್ಟೇ ಇನ್ಯಾವುದಿಲ್ಲ ಅದ್ರ ಡೇಟ್ ಅಂತ ಚೆಕ್ ಮಾಡ್ಬಿಡಿ. ಇಲ್ಲ ಒಂದು ಮಾತ್ರ ನಾಳೆ ಲೇಟ್ ಇದೆ.
ಆಯ್ತಾ
ಎಲ್ಲಿ?
ರಿಪೀಟ್ ಹೇಳ್ಬಿಡಿ.
ಅದಾ ಇದೆಲ್ಲ ನೋಡೋದು.
ಇದು ನಾನು ಹೋಗಿರ್ತೀನಿ ಚೇಂಬರ್ ಅಲ್ಲಿ.